Nothing tying any of that evidence to any particular element. In addition, almost all of the purported evidence that's provided is a mold report that's never been designated. There's no experts that have ever been designated by the plaintiffs. There's no disclosures that have ever been provided by the plaintiffs. And so I believe, one, it's not proper for the court or counsel, frankly, to have to go through and determine how causation is shown at all in any way. And so that's the crux of both the objections that are filed to the evidence. And essentially, I don't believe that there is a proper response as to each element. And so we believe that the no evidence motion for summary judgment has to be granted based on what's been provided to the court as of this time. I can go through all of the objections if you court would prefer to. I
You,
understand you have a busy docket this.
yeah, you have 5 minutes to make your whole presentation. So just let whatever you want to spend your time on. And
Yes.
go
So
ahead. You keep
I'm
time
sorry.
for me. Yeah,
So I
5 minutes.
Okay, yes, Your Honor. So of the 700 pages that's been provided, about 400 pages is a mold law report. The mold law report is not it's not a specific human who wrote the report. It appears to be a group that was retained out of Florida by the plaintiffs, not by their counsel. Again, no disclosures were ever provided in this case, and we do have a separate hearing set this afternoon as to that issue. That there is no expert, frankly. So therefore, there is absolutely no evidence of causation as to any cause of action. Frankly, there's no evidence of any element of any cause of action because, again, not only does the response fail to provide a tie to any element at all, but it also just provides evidence which is not competent summary judgment evidence. There's no affidavit proving any evidence. There's no foundation as to any of the alleged evidence provided. There's no deposition testimony. It's referenced in the response that there is, but then the attachments are not, they don't include it. So really all that's been provided to the court is a report by some company that doesn't list a human that says that there was allegedly mold and there's no tie to any health concerns or anything like that that's been provided. And there, again, there's just no attempt to respond as to each element. This case is set for trial on July 21st, Your Honor. And so we're asking that the no evidence motion be granted.
Response?
Thank you, Your Honor. I'll try my best to address all of the issues as well, the things that were addressed in the motions, all within 5 minutes, Your Honor. The first issue is the fact that counsel in their no evidence motion for summary judgment in their motion and also in their argument failed to specify which particular elements of the causes of actions that were essentially raised in plaintiff's petition and essentially have put plaintiff in a position to have to push all of their evidence in the front to figure out which elements or element is being challenged in the no evidence motion for summary judgment. As well stated in our response, there is ample amount of recent case law and the update on Rule 166A that heavily disfavors the type of motion that was filed by defendant in this manner. So that would be my first objection, Your Honor, or first issue, Your Honor. We provided case law as well that in certain situations, very similar to this, where the defendant just filed a no evidence motion and says, we don't think you've proven any element of any of your causes of action. The courts in those cases have been given the authority to strike and deny the motion in its outright, just because of the unfair advantage that it puts me as a plaintiff to have to respond to it. But of course, I still have to respond and provide what we believe is competent summary judgment evidence. The counsel states that there were no ties or connections to the documents that were provided and the injuries. My apologies, Your Honor, if you guys can hear my cat. I got a new kitten and he's getting adjusted to my other cat, so I apologize on that. But in their report, in the Mologger report, the 400 or so pages that counsel was referring to, if I could just give a little bit of background on this matter, Your Honor. The incident is a mold allegation for my clients who lived in an apartment at the end of 2022. And shortly after moving in, they found or discovered what they believed was mold or something toxic in their unit. And so by June of 2023, they were not only notifying the apartment represented by counsel, of the allegation of mold. They also had let them know of their intention to move out. And they also had provided this mold law group report that counsel was trying to say has been never produced or failed to be disclosed. If I could just spend a minute on that particular report. So even before we were able to even file a lawsuit or filed a lawsuit against the defendants, we sent them a letter of representation laying out the facts of this case to establish the causal links as to why my clients, one, are trying to move out, and two, are saying that they want to move out because they believe that they've been exposed to mold. That belief was supported by the mold law group. In their report, they not only confirmed that there was mold in the unit, and they did that through Dr. Jeremiah Bancroft. His name is right in the report. It's a very easy read report. It also was produced in discovery. And it also was mentioned by both of the plaintiffs in their depositions. We counted it out, and Your Honor, we were going to provide this in the next hearing, but each of the clients at different points in their depositions 5 times referred to this Mo Law Group report. And so they talk about, in this Law Group report, Dr. Bancroft, who is a...
So Ms. Coleman, I'm just kind of looking through this right now, all the exhibits. I don't see that. Did you ever cite to the depositions in in your summary judgment response or the attachment to that?
Your Honor, I will look and see. I do not believe that we would need to have their deposition testimony in this as much as we need to, because the Moat Law Group report within it as well has their testimony more accurately around the time of the incident of the things that they were experiencing and saying were not present in their bodies or life prior to the incident. And from those testimonies provided by the clients, the Moat Law Group was able to not only acknowledge that there was mold and they were exposed to it, but also gave a very thorough future medical projection cost and examination or explanation in their report as well. So that's
this is, I mean, I think that what the movement in this case is raising, and it's a legitimate issue, is that you have to have, and I'm just trying to look through this. I don't see any affidavits. I don't see any declarations. I don't see any sworn testimony. I don't see, I mean, I can't just rely on a report. It has to have some type of affidavit or something here, and it doesn't appear like, I assume that it would be somewhere in here. I don't see any type of affidavit or any type of sworn testimony that is attached. Am I missing something?
No, Your Honor, you're not missing anything. So the Moat Law Group
Yeah, but oh, thank you.
testing. Okay.
Yeah, that's obviously a pretty serious issue that there's no evidentiary support here.
Your Honor, if I could, so again, this report, in this case has been in litigation for a little bit over a year. A lot of these issues that are just now being raised were raised right at the end of when discovery had closed. We have shown in the response that we've been doing some pretty thorough discovery on this case, and I would hate for there to be any kind of mistake or misissuance because of an affidavit that we can definitely get supplemented if needed from the Moat Law Group. They are out of Texas, and so their verification process is a little bit different than ours. They do provide their own certification, but if it does need to be transported to support and be credible in a Texas court by getting an affidavit or a declaration, Your Honor, we can definitely get that to you by the end of the day if needed. But we do believe that.
What are your thoughts on that?
Your Honor, I apologize, I didn't hear you, but were you asking
me? What are your thoughts on
well,
that?
One, Your Honor, I mean, the motion was filed a long time ago. It was filed in May, so there's been plenty of time to do all that and thoroughly respond. There's no if you look at the motion, we laid out every single element of each claim and then what was missing. And there are no response that provides. And so I don't understand what the basis would be. There's no motion for continuance on file. There's no request. There is no affidavit in the response. There is no deposition testimony in the response. So, and there is no attempt to incorporate any of the documents, and there's no foundation for them. There's no legal basis to say, I would like to do a do-over at this late stage. We're set for trial on July 21st, Your Honor. We would ask the court to rule there's no basis for any of the things that are being requested in terms of supplementation, providing a response. And frankly, I don't think it matters. I think at the 3 o'clock hearing, we're going to go over what was just, previewed by plaintiff's counsel, but this mold law report has never been designated. So it's not going to matter, Your Honor, because the rules provide you have to designate an expert you want to rely on. You cannot just dump in discovery a alleged report, which I don't think would meet evidentiary standards anyway, frankly. So, Your Honor, there is no evidence that supports what's being stated in terms of the response. It's just more of a generic, general, hey, their neighboring unit had mold, and so therefore they're sick, and therefore it must be that. There's no evidence of any of that in this response. None of it.
Your Honor, may I briefly respond? We do have
Briefly.
yes, Your Honor, we do have a motion for continuance on file. And these same, there were the opportunity to depose these experts also to get more better understanding. It's not a maze of documents where you don't know who is who. These are the three main individuals who have been doing the mold law group report. We just would graciously
You have a continuance of the trial setting. You don't have at least I don't see a continuance of the summary judgment there.
for the trial setting, Your Honor, my apologies. Yes, not for the hearing, but just for the trial setting. And the reason is because parties were recently able to mediate this matter. And in the course of the mediation, an issue came up, and we let the mediator and counsel know that there was a recent blood test that the plaintiffs could do to help tie up the causation that is local, and it takes 2 weeks to give us the results. The plaintiffs are already set their appointment for it. That way, we just wanted a short continuance as well to allow us to get that in so that we can show an even greater support on top of what the Moat Law Group has provided. Not report, but just a test to show that the toxins that were indicated to be in their body after they had moved out of the unit, some are still present in the body, and those particular toxins do have certain side effects that the clients testify to having and experiencing. And Your Honor, if I could also just have this afternoon to supplement with deposition testimony if needed, so that there can also be some kind of verification as well with that, Your Honor, graciously asking.
Nothing's been filed. I mean, we have a 3 o'clock hearing on this. Why don't you guys chat between now and 3? But there's some serious evidentiary issues, Ms. Coleman, here that that you should. I'm not sure. I would maybe talk to. I'm not sure that there's some serious evidentiary issues. So that's about, I guess, all I can say at this point. Why don't we'll reconvene this at 3 o'clock, and I'd encourage you maybe. I don't know your background, Ms. Coleman, but you might want to talk to some attorneys that deal with these summary judgments more often, because it's there has to be some type of evidentiary support. There's not any here, so not any legal evidentiary support. So, but we'll reconvene this at 3 o'clock with the rest of the hearing. We'll see you guys at 3 o'clock.
Thank you, Your Honor.
Evans v. Souls Thrift Store.
Yes, Your Honor.
Your Honor, I think you disappeared again and you're muted.
Second. All right. You may proceed.
Good morning, Your Honor. I'm Stacey Bruce here on behalf of the defendant. And just as you have noticed in the prior hearing, there is a significant lack of evidentiary support as to this motion as well. In this case, we are set for trial August 4th, and we are here today on a combined traditional and no evidence motion for summary judgment. The plaintiff alleges that she fell in a parking lot adjacent to the defendant's store. The plaintiff, similar to the prior plaintiff, did not ask for a continuance. Instead, he just asked you to deny the summary judgment and allow us to re-raise it once he takes the deposition of John Turner. I want to just point out, Your Honor, that plaintiff's request for additional time fails to meet the requirements of Texas Rule of Civil Procedure 166A-D3. There's no affidavit, there's no declaration, there is nothing regarding his diligence in asking for this deposition. In fact, the plaintiff asked for a extension to respond to the summary judgment, which defendant granted after he filed the motion and failed to confer. And in that motion, all plaintiff asked for was additional time due to the trial setting. There was no request for depositions. There was no request for additional discovery. Therefore, plaintiff's request for additional time fails to comply with the rules of civil procedure. He fails to demonstrate diligence. In fact, to date, we have still never received a request to depose defendant's expert. Defendant moved for summary judgment on the no evidence grounds, and that alone warrants dismissal of plaintiff's case. Defendant identified and argues that plaintiff has no evidence that defendant owns or controls the premises. Defendant identified this issue in response to plaintiff's discovery requests on February 13th and said, "We don't own and control the property." Plaintiff's expert designation was April 24th. Plaintiff didn't designate an expert on ownership or control. Plaintiff never asked for any depositions as to ownership or control. Defendant served discovery as to plaintiff on the issues of—
Wait. So, sir, how do you say your last name? Noah?
You can say it like the N is silent, so like Woha.
Woha, okay. Well, Mr. Woha. So I'm looking at your response here, and Ms. Bruce makes kind of a valid argument. The thing that's a little confusing to me is, I guess it's on page 3 of your response. It says plaintiff will assert that that was not the location of the fall. And to me, that's a really critical point in this case. If this isn't the correct location of the fall, then then this summary judgment may not be appropriate. But I don't see anything, and maybe I'm missing that, where you've supplied any deposition testimony or any type of sworn affidavit or anything to say that this is not the location of the fall. I guess that's something you want to bring up in the future, maybe. I'm not sure.
Your Honor, I'm happy to respond to that. I think part of the confusion is based on defendant's presentation of this. She confuses and conflates a lot of different issues. As it relates to this, what we're talking about here, the traditional summary judgment is something the defendant has the burden of proving. We don't have to disprove anything. They have to prove their case. Now, they provided an expert report, and the expert report says that the client fell here, and based on the fact that she fell here is not on based on where here is, the defendants do not own here. So the expert is basically saying where this person fell is outside of the location that the defendant owns.
But it's a traditional and no evidence summary judgment, right?
Yes, Your Honor. Now, as far as the no evidence side of things, we provided evidence as to the no evidence side of things. And again, it only needs to be a scintilla of evidence. We don't need to marshal all our evidence and put up a case.
What evidence did you, maybe I'm missing it. I don't see that you attached any evidence to your response.
The evidence that was attached was a medical record wherein the client states how she fell, where she fell, and how she was injured. Or the client states that she was injured. She was injured via a fall, the date of the fall, and the manner of the fall. And so that is more than a scintilla of evidence that she was injured falling at this location. And again, the scintilla of evidence does not need to prove our case. It does not need to be dispositive. It merely needs to take the facts in controversy out of the realm of pure speculation and into the realm of genuine dispute.
Well, what you attached is not sworn testimony. It's just a medical record, right? It doesn't even have an affidavit attached to it.
I do not believe that the evidence added to a no evidence response needs to be sworn testimony. I was not aware of that. I understood it only to be evidence in itself. I don't think we need to provide sworn testimony necessarily, just that it be evidence that raises it out of mere suspicion.
Ms. Bruce, do you agree with that?
I do not, Your Honor. More importantly, nothing in this medical record shows that defendant owns or controls the premises, and that is an essential element of a premises liability case.
I disagree with that. I believe it's duty, breach, causation, and damages. I mean, you can maybe argue that a part of duty is ownership, but I don't think that ownership has ever been, as I understand the cause of action, I don't think ownership is a, am I frozen? Oh, my screen is frozen, but can you guys hear me?
We can hear you.
Okay. So, but even if it is to say that, you know, we have a duty to prove ownership, which I don't think is something that anyone does in any premises liability case. I don't think ownership is something that, you know, we need to bring in an expert. Like earlier, she says we needed to bring in an expert to prove ownership. That's never been something that is done in premises liability cases.
So I agree with you. You don't necessarily need an expert to prove ownership, but you need something. I mean, Joe, I mean, you provided no evidence whatsoever.
May I, Your Honor, real quick? To go deeper into the matter of ownership, first off, this is their own parking lot. So this is so even if we can't prove ownership, we can certainly prove control. This is their own parking lot. This is the parking lot that their customers park in order to access that building. The second thing, the ownership argument is improper because if they were not, and they tried to make a third party designation recently, the deadline for the third party designation has passed. We've asked them in a discovery request, and this is on a separate motion to object to their third party designation, but we asked them in discovery requests, please list any other entities that you believe are responsible for causing or being responsible for this injury. They objected to it. They listed nobody. And now, mind you, these discovery requests were due back in February. Now, the statute of limitations ran in April, middle of April. They had plenty of time to designate a responsible third party. They didn't disclose anyone. They objected to our questions asking for a responsible third party. And now, after the statute of limitations has ran, they want to pop up and say this person's responsible. I'm sorry, that's not how it works. If you felt like somebody else was responsible, you need to list that person. You can't hide the ball for months. And then after the statute runs, now you want to blame somebody else. Going back to the ownership issue, this is their parking lot. They had possession, custody, control. You only need to prove one of them. They had control of their own parking lot. And if they want to sit here and say that they didn't have control of their own parking lot, then
Mr. Waller, let me just say this, that all the stuff you're arguing is great, but it's just there's nothing in the summary judgment record that supports that. So I'm going to take a look at this. We'll get you an answer within the next 2 weeks. You have a great rest of your day, guys.
Your Honor,
Thank
may
you.
I briefly respond to what he just said?
I need to get to the next hearing, so we'll move on. I'm going to look at the record. All right.
Thank you, Your Honor.
thank you, Your Honor.
Okay. Smith v. Royal Arms Condominium Association.
Plaintiff is present, Your Honor.
Your Honor, Julie Blend for the movant and the defendant, the Royal Arms Condominium Association, and I have my client representative in my office with me as well, the president, Mr. Nick Harrison.
Your Honor, you're frozen again.
Give me a second. Okay, let's go ahead and proceed. I've read all of this on the Smith v. Royal Arms case. You may proceed.
Your Honor, I've had my motion for summary judgment set first, so if I may proceed first, and then the plaintiff also has her own motion for no evidence and traditional motion for summary judgment. On our motion for summary judgment, Your Honor, the lawsuit was filed on August 25th of 2025. This motion solely relates to the statute of limitations defenses that we have pled against all of the plaintiff's claims. She basically sues for injuries that she claims began in 2013 to her cosmetic repairs and whatnot to her condominium unit located at the Royal Arms. She brings 4 claims. The first
Right,
is
I've read all of that. What I guess I'm most concerned about is there was a settlement agreement, right, in 2015, I think, or 2014. Is that right?
Yes, Your Honor. There was an assessment lawsuit that the association brought against her, and it resulted in a mediated settlement agreement, which was signed on October 21st of 2015, which called
It, it, it is part of that you guys agreed that you would make these repairs, correct?
Well, Your Honor, part of the agreement is that the foundation repairs to be made would be Piers foundation repairs. That's what's in the agreement. And there's a report that was issued in 2018 by the Jensen Company, which indicates that there was no need to put piers in the foundation, that the foundation was within the normal limits of a building of this age, and that no foundation repairs were necessary. And then there were also
Didn't it also require cosmetic repairs as well?
Yes, Your Honor, up to $5,000.
And that wasn't addressed and that has not occurred either, correct?
No, Your Honor, that has not occurred, but we have alleged
So let me ask this then. So there were multiple representations over the course of many years where your client kept saying they were going to make these repairs, they were going to make these repairs, and then they even raised the issue that, hey, the statute of limitations is run, but we'll still make these repairs. Does that extend the statute of limitations by making these additional promises, or should we relate it back to 2015?
No, Your Honor, it's our contention that a cause of action accrues whenever there's a wrongful act that causes a legal injury. And the indications in 2018 were that once this Jensen report came out, is that any repairs weren't going to involve piers.
But what is the wrongful act here? Is the wrongful act, I guess my thought is, and I didn't feel like this was fully briefed, but your client continued to make promises that they would make these repairs up through, I don't remember the last date. Mr. Payne, what was the last date that they continued to make this promise?
The last day, Your Honor, was in January of 2025, a little more than 18 months ago.
Your Honor, I don't believe that there were any promise to make repairs in 2025 at all. And in fact, in the summary judgment record, the plaintiff actually hired a different attorney back in 2020 to send a demand letter against the association to make the repairs, the cosmetic repairs and the foundation repairs. And she didn't sue. For her cause of action to be valid, it would have to have accrued on or after August 26th of 2021. And the evidence in the record shows that it accrued.
But why doesn't it, if they're continuing to make promises to make this, why would, and it's saying that we're going to live up to our agreement and they continue to make that, why doesn't those continuing promises extend the statute of limitations?
Because, Your Honor, they weren't saying that they were going to make Pierce Foundation repairs. The plaintiff kept insisting that the repairs that to be accomplished had to be attached to this Douglas report from 2013, and it involved putting piers in the foundation. And the engineers who looked at the issue in 2018 and then in 2023 and then actually 2026 all indicated that piers were not necessary to correct any foundation, that the foundation was structurally sound, and that those repairs were not required.
All right,
So-
Mr. Payne, what's your response?
Well, just as you said, Your Honor, there are continuing acts by the HOA which made it very plain that they were intending. In fact, one of them from their attorney says, we're still honoring our obligation. Every time that we questioned them, they gave an explanation that, well, we can't do it at this moment, but we're going to do this, we're going to do that. It's a continuing obligation as well. It's not simply a situation where because in 2015 or 2013, you didn't do the work, you still have a continuing obligation to maintain and repair and replace as necessary. And every day that goes by is a new violation.
Your Honor,
And the fact that they keep promising something, Your Honor, I think is exactly as you said. It continues and pushes the statute of limitations back. And whether it was 2025 or it was 2023, all of those were representations that we relied on. And we have stated in our pleading that only in 2025, when they came to us and said, we're not doing anything through their management company, this matter is closed, did we perceive and understand for the first time, because there wasn't an explicit denial at any time up to that point, that the statute, that they were in breach and we were going to have to sue, and we did.
Okay, so let me tell you what I want you guys to do. That's kind of how I understood this. Have you guys already submitted a binder with all the briefing in this case?
I don't know if we have, I don't think my side has, Your Honor. Plaintiff has not.
we've just e-filed our briefs.
Okay. I want you to prepare a binder. This is how I want you to do it. So there's a total of 2 or 3 summary judgments in this case.
2, Your Honor.
Okay.
Well, his is
So,
combined. No
Well,
evidence
3.
differential.
It's a combined one on my part, Your Honor.
okay. Oh, it's combined. Okay. So I want you to prepare 2 binders for me. That's the first thing. The plaintiff, you prepare a binder that has your motion, their response, any briefing, any case law, any exhibits. You prepare one binder for your motion. Ms. Blend, you provide one binder with your motion, their response, any other briefing, reply briefs, all that kind of stuff, any case law with exhibits. I also would like an additional 2 to 3 page letter brief on the issue of, does the continuing promises extend the statute of limitation? That's really kind of, I didn't feel that was fully briefed in the case. So I'd like to get a 2 to 3 page letter brief by this Wednesday and include that in your binder. I'd like the binders by Thursday. So include
Your Honor, I apologize for interrupting. I am on vacation up in Michigan through the 20th. I apologize, but that time frame is unfortunately unrealistic for me. I'm a solo, and I don't have somebody else I can turn it over to.
All right, Ms. Blend, then you can prepare both of the binders, but I do need this. I'm sorry, Mr. Payne, I need the trial brief. If you want to write additional briefing, you're going to have to do that. But I'll have Ms. Blend. You'll owe her one, but you can do both of the binders, Ms. Blend. But I still need that trial brief, the letter brief. So I don't know what else to tell you. I need that by Wednesday. But Ms. Blend, you prepare both of the binders. Does that make sense?
Yes, Your Honor, by 5 p.m. Thursday, delivered to Ms. Pinson.
Yes.
Thank you.
All right. Thank you, guys. You have a great rest of your day, okay?
Thank you,
Thank you, Your Honor.
You too.
Take care.
Bye-bye.
Bye.
isn't it hard to do this with the smell of Chick-fil-A? I don't know. You guys may be more used to that. All right. Anyone here on the Ned versus Commercial Metals case?
I'm here on behalf of defendants, Your Honor.
And there's a Jackie Mitchell or Jackie Adiola Michael. I'm sorry, Jackie Michael. What are you here for, ma'am?
The Ingrid Huntington.
Yours is next. Okay. All right, Miss Farrett, you may proceed. It doesn't look like there was a response filed. Is that correct?
There was not a response filed, and I did actually speak to the plaintiff this morning. He told me he would not be attending the hearing and he would like to have the case dismissed. I don't know I can proceed with arguing my motion if you would like me to do that, but I just wanted to let you know that first off.
No, Paul, but I'm not going to non-suit it. You don't have the ability to do that. I'm going to sign the summary judgment order.
Okay.
I mean, unless you disagree, but I don't think I could allow him to non-suit it because he's not here.
No, I spoke to him and I did tell him that he would have to file the non-suit or a motion to dismiss if he wanted to. He currently does not have counsel, as you're aware, so I'm not sure. I think we'd have to prepare it on his behalf and mail it to him maybe, or I'm not really sure, but regardless.
I'll give you two choices. I'll sign your summary judgment order, or you can withdraw the motion.
We would prefer that you sign the summary judgment, Your Honor.
Okay, that's
Okay.
fair.
Thank
All
you.
right. You have a great rest of your day, Ms. Fair.
Thank you. You too.
Miss Michael, aren't you set at 10:45?
Yes, Your Honor.
Where are the rest of the attorneys?
Well, I didn't see that anybody filed a response, and I did talk to plaintiff's counsel. He's unopposed to my motion for summary judgment, so maybe that's why he didn't show up.
Okay. Let me look real quick. I want to make sure I'm signing the right order. Did you file an order with this?
Yes, Your Honor.
Let me see. You represent McDaniel Yardscaper, is that right?
Yes, Your Honor.
And
Let me
I
go
don't
back and
see
look.
order. I can share screen somebody's in the chat here.
I'll get that filed immediately if it's not on there.
Here, I'll share screen. I just don't see it. Can you see that on the screen? This is what we have. You filed on 6/1, and I see you noticed.
Yes, I do see that.
Order granting quest something. There's an order substitution counsel. I don't see an order granting the summary judgment.
Okay, I'll get that filed immediately, Your Honor.
All right, yeah, I need that within the next hour. And make sure you email Rhonda. Rhonda, are you there?
Yes, Judge, I'm here.
Make sure we get that.
Okay, let me get Rhonda's email address.
Sure, I'll put it in the chat.
Thank you so much.
All right, thank you, Ms. Michael. You have a great rest of your day.
Thank you, Your Honor.
Very good.
Thank you, Rhonda. I got it. Thank you so much. I'll send that over immediately.
Okay.
Thank you.
Thank you.
So this was an incredibly busy morning when it comes to hearings. So, but we still have some more coming up. If you guys want to grab your lunches. We have about a 10-minute break. So if you guys want to grab your lunches, I order. So if you guys want to, I basically got just chicken nuggets for everybody. Save one for me. There's one wrap. Give the wrap to a vegetarian here. It's a big one. Oh, that's
It's for everybody, but I can get you another one.
Well, great. Thank
Is that
you.
banana?
It's not, but it's got food.
Just okay. Okay. Sounds good. No, we can get some, get that for dessert. Yeah. Okay, so I got waters for everybody. I hope they got enough sauces. Let's just. That's one of the things. Water needs water. That's a good question. Let's do this real quick. After everyone's got their food, why don't we have everyone, I should have done this together. Everybody want to force you guys to introduce yourselves, where you go to school, where you went to undergrad, and a fun fact about each other. About yourself. Something that would not be obvious in this. But nothing to embarrass. Everyone get the nugget, you take, there you go. Everyone get this same amount, get chicken nuggets, yeah, or chicken nuggets. So everyone, Maggie is a one, intern right now is not yet in law school. And she's gonna be with us for 6 weeks. I don't usually let people do that this day, but she's very consistent, so. She's gonna be supporting you guys and also. We have other interns with all the general interns. She's gonna be coming to super. So. Does anyone have any questions at all or anything so far? That's a good question. Dismissal for one prosecution. So, question. Oh, good question. You all parked in the Jackson Street garage? Yeah. If you did not park in the Jackson Street garage, you are not getting a discount today. Sorry. That was in many of the emails I sent you. That's the only place you can get a discount. You have to park. Otherwise, they do not get this. So, also, did you guys bring your statements and appearance? Okay, go ahead. Bring all those in the mic. Yeah. You did absolutely. No problem. Yeah. That was it. So if you got, hey, one thing I want to just say, guys. You're gonna see some great water. Your 6 weeks here, you're gonna see some bad water. You saw some very bad water. You have 2 claims returned to you. And unfortunately, did not see any evidence to respond to the summary judgment with any legally recognizable evidence. And they probably are gonna lose their cases on behalf of the clients because they didn't follow the rule. So. Don't do that. They're trapped over here and over there. Anyone not giving your statement of appearance yet?
Me. I need to print them.
Okay.
I'm right next to one.
Okay.
Thank you.
Okay. I think we're all here. First off, let's give Beck a big round of applause for bringing us food. We had to enter the last group that Emma Thomas, you guys know Emma, and she would bring in stuff every week. So now that's the expectation. So then if we need that. What?
No,
She was so good. We are trying to. All right. So everybody have a seat real quick. Let's go ahead and have our introductions. Why don't you go ahead? We'll start with team one. Team one, each of you introduce yourself, where you were at law school, where you went to undergrad, and fun fact about yourself.
Morning, everybody. Morning, everybody. I'm Michael Prattenberg. I go to Baylor Law School. I went to Texas A&M for undergrad. Thank you. All right. A fun fact about me is I build mechanical watches as a hobby.
Oh my gosh. That's really cool.
Good to be here.
You have one on?
I do, yes. I
You built that?
Sir.
That's one of them.
Yeah,
Not that.
My name's Austin Waits. I go to law school at University of Texas, also an undergrad there. My fun fact is that I'm married to a person my age.
This work.
Linda Law Group. It's a small-
I know, I've heard of it. Yeah.
I'm Fernando. I also go to University of Texas. I went to in Houston at UH. And my fun fact is back in Austin, I'm in a punk band.
Oh, wow. What's the name of the band?
This river stinks.
This River Stinks.
Yeah.
What's the story?
My drummer came up with it. All the ideas I had flew out the window. I wanted it to be
Okay. Singer, the most famous line in your song.
oh, I don't know.
Just say.
Are you sure? Like community next?
Who cares? You got shot me yet?
Okay. Oh, that's a good one. Love it. Good
morning, everyone. My name is George. At Baylor Law, so the grad at Baylor University. I work contracts with the and
We have a punk band?
I'm not a punk band. I do a lot of traveling as I'm trying to guess the skill. I know next week.
So say that again.
I want to, well, I'm trying to check out there this month.
Like every country in the world. How many you been to?
The guy like
That's impressive.
I have a friend of mine who I got through, I think I'm like 15, 20. I have a credit card too, so
That's good.
it's about 2/3. So
Did you should get watching the World Cup for his birthday?
yeah.
No, yes. All right. Okay, go ahead.
Hi, Alia. I also go to I nearly saw your name. Yeah.
Wait, how do you all know each other?
Oh, we both went to SMU.
Oh, wow, undergrad? Okay.
I guess my fun fact is I performed the musical Oklahoma in South Africa.
You performed the musical Oklahoma and South.
Yeah, because I was there for study abroad, so I went to for them and we do a collaboration with the theater department there. Instead of the transport flyers.
So I really want to do a mashup between you two, where you're singing Oklahoma, you're singing that song about getting shot at the head. Yeah.
That would be awesome.
Great mashup. Yeah. All right. Your turn.
Yeah, I'm Nicholas Behan. I go to Baylor Law, and I went to undergrad at UIW, a small town school in San Antonio.
University of Colorado.
Yeah, University of Colorado.
Yeah, I went to Trinity, right?
Right. So you know what's cool.
I do.
And fun fact about me, I played football at school, and I'm a big sports fan, so I don't know what you thought about Spurs game.
Spurs.
Go ahead. Are you a Spurs fan or Knicks fan? Like in that series?
Spurs, definitely. I mean, I grew up in Corpus Christi. I went to college there. It's hard for me after the Luka trade. I became a huge Mavs fan, but then I was so furious at the franchise after the Luka trade. For a while, I became more of a Spurs fan. Glad to break things out with that. But I love this one. Great team.
It was just sad to watch that.
You believe in the conspiracy theory about how like Luka could have listened there?
No,
That's one good thing. Like every year that like the team trades one of their best players to
It's like an LA team.
Yeah.
That's how they get, yeah, that's like,
It's a weird, it is a weird place, and it's not like 2 or 3
it's
times.
happened like 4 times.
4 times is
This
okay.
one, they gave this, it's animal.
I don't want
Morning, everyone. My name is Zaid. I'm from San Antonio, but I'm also a huge Spurs fan.
to. Look at that, Spurs fans.
I went to Texas Tech for undergrad. I go to UNC Dallas College of Law. And I think I can contribute to the mashup project.
Oh, good, all right.
I taught myself how to DJ during COVID.
Oh, wow.
So I still kind of do it. as
So
a
you can
hobby.
do like the backseat.
Yeah, I can kind of remix it in and out.
Is that the right way to say it, the backbeat of like
Maybe the instrumental.
the instrumental, that's better, all right. Do people not say backbeat anymore? Is that the
I
thing?
haven't heard it.
Okay, all right. Throw it by age, guys, throw it by age, all right.
My name's Charles Head. I go to UNC Dallas College of Law. I went to undergrad at Austin College in Sherman. Fun fact, I was a football coach to College University before I was to law school. Yeah, that'll be it.
It's Michael Shelton. I go to UNC Dallas. I graduated from the University of Oklahoma. Fun fact, I played golf yesterday and shot a 96.
Wow. You need golf or real golf? All right.
Hi everyone, I'm Ava. I also you can see now. I'm from Boston. And one fun fact that I love marriage, so I make like food plates and pretzels. So I can make y'all's food plates and show with fries, windows. I love.
Morning all, my name is Russell Cooper. I've been to UNC Dallas, undergrad at TCU. From the back, during the undergrad, I was kind of long that out. So, that's there, yeah. Oh, so, right, have a great career.
They'll have to tell you to see that. Yeah. Hopefully it works off, but they're not down. Yes.
I'm Matt, I'm from New York, so. Champion.
Wow.
I go to Texas Tech, for law school. I went to UT for undergrad. And a fun fact, I've been to 29 of 30. Just missed 29. Just missed in Miami.
Wow, okay. I've always thought I would do it. All right.
Hey, I'm Jeff. I attended to be the law. I'm from Hawaii, so I attended fun facts, I moved into roller sports and I totally cool. Other just have one, and then it's it.
Hi y'all, I'm Sandy from UNC. I went to undergrad at UTU. And a fun fact about me is I'm building a library, so I currently now have 3 funding books. It's super fun to me. And I'm getting to.
Okay.
Hi, I'm Hannah. I go to UNC Dallas. I went to Baylor for undergrad. And I've been really thinking about my fun fact this whole time. And I haven't come up with anything other than I have a cute dog and I'll show you the picture.
No, we gotta do more than that. Come on.
I won't form.
We do that better than 96.
Yes.
Probably. Yeah. Now what your fun facts would be. Okay. Your nickname.
Oh, well, yeah, okay, so I'm Daniel Wilkes, his nickname for me is Johnny on the Spot, because apparently I was a pretty decent best hint. I used to do it 2 years ago.
How many people have ever heard that term John on the spot? I don't know. Who's never heard it? You heard the term?
From a video game, but I
Oh,
don't.
really? A video game? Wow. It's which video?
Yeah.
Is that, what does it mean in video?
It's like you call your mechanic and he brings the car You requested R, he said, I'll be down on the spot.
Interesting, okay, so he was like, you're seeing how these, people would come up and choose would come up and doing that. He was always really fast, and whatever I asked him to do, he played fast. But that's not his fault.
So when I was still center, I was at two university for undergrad, and now I'm still there for law school. Last year, one fun fact is at one time organized a personal that I read.
Wow, interesting. Did you live there? And just
When I studied abroad there, I was in a smaller town called Maastricht.
Oh, wait.
They had.
I was in Australia.
It's.
what year was it?
Uh,
Did you go to
this
the-
was- So-
That would be crazy. You did that, oh my God.
There's still one place I like those.
Yeah.
And it was the SBA, that was a part of.
Was it like near the lake?
Yeah,
Yeah.
like right across the river.
Yeah.
That's possible.
We were there in 2024.
I was there, it would have been my fault.
Oh my gosh, you guys almost got signed. All right, that's good. And then get started there for second, May.
I'm a guest intern. I'm gonna go into my junior year at UTM, so fun fact was I took myself on for 2 years ago. That's on top, but also I was going to.
That's what my son worked, yeah, that's how I met you, I think, right?
Through Kara.
Yeah.
Yeah.
So my son worked there for 3 years, before law school. Great firm. All right, guys. I think that was interesting. You got to know each other a little bit. So let me have Ron fill out this form and see.
That's awesome. It's one like.
Yeah.
They were children. You should miss that.
All right, these are the forms you guys have to fill out. And what will happen is you guys will get a badge by the end of the day, hopefully, and that will allow you to get out reduced price parking if you're. You know, like, not young right now. I know.
So I wanted to started with. Listening to a lot of books and then and then I took those. Yeah, so I went to school for a lot of books. My little sister.
Water.
You've been reading.
I looked at it.
Not my
All right, guys, we have another hearing. All right, is everyone here on the Meehan versus Texas Health Presbyterian Hospital case?
That is correct.
I believe you are, Your Honor.
You guys may proceed.
Your Honor, I don't know where you want to start. Maybe the easiest place to start, I know our time is limited today. My name is Alan Campbell. I represent Texas Health Dallas. We have a motion for continuance. It's filed by both defendants before the court. I think at the time we first started discussing this, Ms. Martini had some reservations about the scheduling order, but we got that, I think, rectified to her satisfaction. And we have a scheduling order before the court that I believe that all parties are in agreement to. I don't think Ms. Martini has any opposition to the new scheduling order.
So guys,
Actually, we were looking at different dates. I think we were looking at a May trial date.
guys, this case, sorry, maybe you guys can hear me. This is Judge Hoffman. This case is over 2 years old. You're going to have to give a very strong reason why you would need a continuance on a case of this age.
I can provide some explanation, Your Honor. First of all, it's Chapter 74 case. We had a discovery stay until plaintiff served their expert's report. And then thereafter, pretty soon thereafter, we began asking for Mr. Mayan's deposition. Unfortunately, his medical condition was such that he could not give a deposition. And he had a kidney transplant at around the time we were asking for his deposition, and his doctors would not allow him to be deposed until November of 2025. That represented about a 6-month delay. So that's part of the issue. I can go into the detail. Ms. Martini was away out of the country, I believe, for about a month between February and March of this year. We honored her request to not do any discovery while she was out of the country. We've taken a bunch of depositions. We need to finish. I think my count was about 7 depositions, mostly experts, at least one fact witness. So that's kind of where we are.
Have you been to mediation?
That's another thing. We kind of, I told Ms. Martini I didn't want her to incur the expense of experts until we mediated. We did that a couple of weeks ago. We did not settle.
Who did you mediate with?
Mr. Dan Marley.
Yeah, okay. I think you guys, everyone who does med mal should know in my court that doesn't count as a mediation. So you're going to have to go back to mediation.
Who would you prefer, Your Honor?
Anybody. But I mean,
Should we then meet on our own, or do we need to get something on the record today, Your Honor, about whom we should mediate with?
Who do y'all usually mediate with? There's a few that are really, I didn't mean to interrupt you, Ms. Martini. Who do you usually mediate with?
Joel Steed, Mike Pizzulli, Wayne Little.
There's Bill Dipple.
Kevin Onken. Ken Dipple.
My clients would approve of Bill Dipple.
I'm sorry, Ben Dipple.
I'd be happy to reach out to him today, Your Honor, after this hearing and see what we can schedule with Mr. Dipple.
Is Dipple local? I'm trying to remember.
Yes, Your Honor. He's here in Dallas. I believe he's with Gammon, perhaps, or Gammon or Burden, one of those two.
It's Burden, Your Honor.
Okay. And any of those is fine. I mean, Joel Steed has been the one has had the most success in my court, but I just don't know. I know his availability is difficult.
I'll be happy to reach out to him as well, Your Honor.
I mean, I don't have a strong opinion. I don't have anything against Dipple. Joel Steed has been, I think, settled all but one maybe case, and I've sent him quite a few. It's just he's hard to schedule with. Why don't we do this? Why don't you reach out, Miss Martini, to Mr. Steed and Mr. Dipple, find out some mediation dates, and then we can. I really don't want to continue this case. I might continue it a little bit for mediation, but given the age of the case, I mean, you guys, I'm sure, heard from other judges, not just me, that with all these new requirements the state is putting on the judges, we just are getting a lot of pressure about not continuing cases. And so I don't really like that. And I, do as much as I can, but the case is 2 years old. That's going to count against my numbers. It's going to be, it's problematic to move a case of that age. And so, so what I would suggest we do is we'll have the rest of the hearings, reach out, Ms. Martini and whoever else wants to Steed and Dipple. Let me know what the dates are. We might move the trial setting a little bit. We're not going to move it into next year. So, and we can reconvene this afternoon if that works for everybody.
I can be available, Your Honor.
Certainly, Your Honor.
Yes, Your Honor.
Does 2 o'clock work for everybody?
Yes, Your Honor.
All right. What else? We also have a summary judgment set for today. Is that right?
We do, Your Honor.
Okay, go ahead.
This is defendant's Texas Health Dallas's motion for summary judgment on gross negligence. I won't belabor the court with what's in our motion, but essentially we don't believe that Ms. Martini's summary judgment evidence establishes any element of gross negligence. She has cited some experts' reports, and we can debate the content of those reports, Your Honor, but they simply shouldn't be considered by the court because they're not summary judgment evidence. Ms. Martini has attempted to authenticate those reports with an affidavit by herself, and the cases, as you know, that does not save those reports. The reports are hearsay. She's not a doctor, and so an affidavit saying that they're true and correct copies or that's when she served the designation doesn't save the evidence. They should have been sworn to by the experts. Case law is pretty clear that expert test. I'm sorry, I didn't interrupt.
No, that's okay. I don't disagree with you, but it is, to me, that would make that a defective affidavit that she could correct. There may be case law. That's just my initial thought. That's not a ruling. Ms. Martini, why did you do it that way? Why didn't you have the doctor?
For 2 reasons, Your Honor. First, my affidavit did not authenticate or prove up any of the expert reports. It only proved up the service details of when I served the expert reports, because one of the arguments in the motion indicated that there might be some basis that they might have been untimely. So I just wanted to show the court that those were served on a timely matter on April 1st, subject to our Rule 11 agreement to extend designation deadlines. And I do think
you could do an affidavit on that.
Correct. My affidavit did not address anything about the expert reports. To the extent I used those expert reports in my response, I referred to the motion, and there's a Texas Supreme Court case from 1993 that says that if a party uses evidence in their motion, I can rely on that in my response. And that's exactly what I did. The defendants can't use those expert reports and argue that they support their position and then claim those same reports are not competent evidence when I use those reports as to prove my points. And that's exactly what I did here.
Okay, interesting argument. Mr. Campbell?
Your Honor, they were simply cited to show their deficiencies. They're not summary judgment evidence. It's on the burden on the respondent to provide the summary judgment evidence that defeats the elements of gross negligence. We need the sworn testimony from the experts, and we don't have it before the court on these issues.
And Your Honor, the court has to review the entire record on file, including the move-ins evidence in the light most favorable to the movements. And that's all we've asked you to do. Now, if the court determines that there is that deficiency, then we would ask that we be given the mandatory opportunity to cure that defect.
The other point, Your Honor, the only other point that our motion raises is that imposing gross negligence on a corporation requires the identification of a vice principal. The only person that the plaintiffs have identified in their summary judgment evidence is Nurse Johns. Nurse Johns is not a vice principal. She doesn't have the authority to hire and fire. She's not in charge of anything, not in charge of a division, not in charge of a department. So that's the other, we believe, fatal defect in their response.
On that point, Your Honor, that issue wasn't raised in the motion itself, so it can't be considered in this hearing. It was only presented in the reply brief. And a ground raised for the first time in a reply brief cannot support a summary judgment. And even if those issues were true, it's unfounded because there are direct corporate liability, vicarious liability, I'm sorry, not vicarious, but we have the respondent superior, and we're also making allegations of direct corporate liability against the hospital for institutional failures. And those are addressed in the motion. I'm sorry, in the response, but I'd be happy to delineate those for you if you like.
So there's a couple interesting issues here that it's. I have a whole new group of interns here. If you were in the courtroom, you could see all multitude of them. And we had 2 hearings this morning where the plaintiff's attorney failed to present any evidence, valid evidence, in a summary judgment response, which was kind of fatal to their to those motions. This raises kind of an interesting issue. There was an affidavit that was filed, and then I don't know that I can consider that in a, attorney's affidavit. Is that a defective affidavit that can be corrected? I don't know. That's a close call. And then the other issue, obviously, is the defendant attached the exhibits, the expert affidavits or expert reports. Is that something the plaintiff can rely on? Generally, I would say yes, but if it's not competent summary judgment, I don't know. That's just an interesting issue. I've not seen that before.
Well, on that point, Judge, there's Guerrero, and the other one is Kohler. I'd be happy to send that to you so that you can read it over the break, and then so you'll have that information when we reconvene at 2 o'clock.
Are those 2 cases that address that issue, Ms. Martini?
Yes, Your Honor.
Yeah, go ahead and email those to me.
I'll email them to all the parties. Do you want me to email them to the court, or should I file them?
The cases, are they cited in your briefing?
I believe that they are.
I haven't seen them, Your Honor. The only other comment that I would make is even if we accept the reports for what they are, there's no sworn testimony. They've never been verified by the experts themselves. Ms. Martini has confessed to the court today that she never even intended to somehow turn those reports into sworn testimony. They are out and out hearsay. And I submitted them. I didn't authenticate them either.
Just by virtue of filing them, Your Honor, they're authenticated by the defense once they attach them as exhibits and use points within those reports to substantiate arguments they're raising in their motion. They can't have it both ways.
Yeah, it's that's why I say I don't know. I don't.
But my point was, Judge, even if we accept those, even if what you say is true, they are still conclusory.
But you submitted them.
I'm saying true.
You can't object to your own evidence.
I'm not objecting. I'm saying they're conclusory. They don't, as we cite, we've never cited them as valid and truthful. Obviously,
objecting to them being conclusory, but they're your evidence. You submitted them, not her. You can't object to you can't say I'm submitting this and I'm objecting to my own evidence. I mean, I don't know. That's what you're doing. You're objecting to your own evidence. I don't know. Let me look at these two cases. We'll see you guys at 2:00. Okay.
We have one more matter, Your Honor.
What's that?
It's a motion to strike one of Ms. Martini's experts under Chapter 74.
I thought it was, we're doing the motion to compel today.
No, we withdrew that
Well, I didn't get a
for
notice.
the time being.
I didn't get a notice of hearing for the.
It is on the notice if you check it. The 3 matters that are before the court today.
Okay.
According to what I have, the motion to strike is set for 7/24.
Your Honor, it's in, I think it's been accepted by the clerk. It's dated June the 30th, 2026, first amended notice of virtual
So I have
hearing.
Defendant Patel's motion to strike Dr. Sambarsona. Is that what we're talking about?
No, Your Honor, it's the motion to strike Joshua Simon.
Let me see. What day was that filed, the notice?
June 30th, Your Honor.
I haven't noticed for a continuance on June 30th.
The only notice I've seen for Simon was for a hearing on the 24th, Your Honor.
I'm looking at the file stamp version. It's a letter from me dated June 30th, 2026, and it's entitled First Amended Notice of Virtual Hearing.
Let me see. There's a number of notices. Okay, I see it.
It says, please be advised that Texas Health Presbyterian Hospital Dallas is motion to strike.
It says defendant Texas Health Presbyterian Hospital's objection motion strike is set for July 13th.
The letter I'm reading says it has been stricken from the July 24th, 2026 hearing docket and reset for July 6th, 2026 at 11 a.m. in the 68th District Court, Dallas County. This hearing will be conducted virtually. The Zoom information is below. That was filed 6:30 at 3:42 p.m.
Okay. Is this on the motion to compel or this? Okay, I'm sorry. This is not on the motion. Okay, you said it was set on July 30th. Okay, there's a lot of stuff set that day.
That's the date of the letter.
Okay, let me see.
June 30th is the date of the letter, the date of the notice.
Okay.
And I say that our hearing on the motion to compel that was previously set for hearing today is canceled. On further in the letter.
I'm confused. Who struck that from the docket?
Well, me and Tanya had a conversation. She wanted it to be heard.
There was a conversation between Ms. Campbell Jones in my office and Ms. Martini, and she wanted it heard on another date.
She wanted it heard so she would give us dates for Simon.
So she could give us dates for Mr. Simon's deposition.
Whoever is talking can just talk. I don't know who that is, but I could hear you talking, but we can't hear. What happened, ma'am?
Miss Martini and I had a conversation, and she was withholding dates for Mr. Simon's deposition until you made a ruling on this motion to strike. And she said, well, let's just have it heard on this July 6th hearing, and then we'll have a ruling, and then I can give you dates. And I said, okay, well, I'll have it stricken from the July 24th, and we'll move it to July 6th. And so that's what we did.
Okay.
That's not what I said. I said, let's have it heard, and then I'll be happy to give you dates, because it makes no sense to produce him for deposition when you've moved to strike him as being unqualified to testify as an expert under Chapter 74.
That's what we said.
All right, let's do this. Okay, if we're keeping the trial setting we have now, we probably need to get this decided right away. If we're not keeping this trial setting, then we can probably move this motion to strike. I can get how there was kind of a confusion here. I'm not blaming either side. So why don't you guys get me the new dates, give me some dates for the mediation so I know what's going on. You might want to talk about some dates this year that you want to move the trial setting to, and then we'll discuss that issue on the summary judgment, and you'll submit those cases to me, Ms. Martini. We'll see you back.
How would you like me to submit those cases? And I apologize, those would not have been in my reply because that issue wasn't raised. I'm sorry, it wasn't in my response because that issue wasn't raised until the reply. So I have not submitted anything to the court to review on the law, but I'm happy to do that. And
Do a very short letter brief that will be filed with the court and emailed to Rhonda. And
I'll do that.
Put it in the title, urgent for judge. Rhonda, she's going to email something that says urgent for judge so I can read it before the hearing at 2.
Okay, Judge.
Thank you, guys. We'll see you at 2 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Anyone here on Frontline Invesco versus Sharma?
Yes, Your Honor. Grace Brigard for plaintiff, Frontline Invesco, and I'm here with John Easter from my firm as well.
Yes, Your Honor. Brian Hale, Drew Morgan, and or Drew Robertson and Morgan Jones here on behalf of Dr. Sharma.
Okay. All right, Tony, you ready?
Yes, Judge.
On the record on DC 259169, Frontline Invesco versus Sharma. Counsel, make your appearances.
Your Honor, Drew Robertson for the defendant, Dr. Sharma. I believe our motion to compel is set first this morning. With me is Brian Hale and Morgan Jones.
Okay.
Your Honor, Grace Brigard and John Easter for plaintiff Frontline Invesco LLC, and we also have our motion to compel set for this time as well.
All right, you may proceed.
Thank you, Your Honor. I know how the court feels about motions to compel, and I know we have a limited time this morning, so I'll just say, of course, we believe the issues have been adequately briefed in the motion, and the court can read that and take a look in more detail. I will just kind of categorize the 3 main issues that are at issue in our motion to compel. First is we're deposing their corporate representative on Friday. We have asked for verifications to interrogatory responses. They first served their amended interrogatory responses over 2 months ago on May 4th. I've asked them multiple times for verifications to those interrogatories, and I was told most recently this morning that they need at least another 10 days to provide those, which would actually fall after the close of discovery this coming Monday, July 13th. And of course, after we've done the deposition of the corporate representative.
So you need to get those in by Monday.
We honestly, we need them before Friday, Judge, when we have a deposition of their corporate representative scheduled. And if he's the one that's going to sign them, I want to have his verifications.
Okay. Well, Friday is fine. You need it in before the deposition starts.
Absolutely, Your Honor. We also have mediation scheduled prior to the deposition. I'll get my client to sign it before then. I have no issue.
So that's the first issue. The other just kind of general categories that are addressed, like I said, in full in the motion. We have a number of boilerplate objections throughout that we've requested be removed. We've heard no response on our efforts to confer on that. We would simply ask that, of course, the improper boilerplate objections be removed. Literally, I believe it was the same copied and paste objections to just about every single request. And even after we conferred on that the first time, we got supplemental responses that still include improper boilerplate. We would just ask that those be removed. There was also privilege objections. We've received no privilege log. We've received no specificity as to what actually is privileged or if anything's being withheld on the basis of privilege. And I believe we're entitled to know that. And then finally, the last major category, we identify specific interrogatories and specific RFPs in the motion. But essentially what we've gotten in the supplemental responses is, well, discovery is ongoing. We're in the process of reviewing documents that Dr. Sharma provided, and we will supplement. Just one example. We've asked in interrogatory number 8 for them, they have one single claim remaining in this lawsuit. And as the court may recall, the court granted summary judgment dismissing the majority of their claims. We're down to a single fraudulent transfer claim. I have asked in interrogatory 8 a basic contention interrogatory pursuant to the Sting Soccer case from the Dallas Court of Appeals and tracking the exact language used in Sting Soccer. And I've said, identify for me on when you filed your petition and alleged fraudulent transfers, identify for me the facts that you're aware of that support this contention that say there were fraudulent transfers. And what we've gotten in response to that is they've identified a couple of transactions. Those are going to be fully addressed by the motion for summary judgment that Mr. Hale will address at this afternoon's hearing. But essentially what we've gotten is a couple of identified examples. And then they say, discovery is ongoing. We're continuing to review documents. We will supplement. Respectfully, Your Honor, when there's a contention interrogatory that says, what were the facts known to you at the time?
Robertson. So I'm going to overrule that objection. That needs to be answered by prior to the mediation.
Thank you, Your Honor. And I would just point out that same objection or this assertion that they're continuing to supplement, continuing to review, that also exists on the others that are identified in the motion, including RFP 8, 9, 13, 14, and 15. In all of those, they continue to say they're reviewing, they will supplement, they will identify. And again, we have discovery closing on Monday. We have a deposition on Friday. I just need complete answers to those so that we know what they're actually.
All of that needs to be supplemented prior to the mediation.
Thank you, Your Honor.
Anything else today, guys?
Your Honor, plaintiff has its own motion to compel that sort of explains a lot of why that statement in the amended responses that we will supplement is important here. We've been waiting for documents, bank statements, documents showing transfers between the defendant and his entities, documents showing the financial status of these entities and where all this money that originally was represented to these entities were represented to be worth $40 million at one point to my client. And now apparently there's nothing left. There's real estate that's listed in tax returns that apparently was foreclosed upon. And we've asked for those documents showing what was this debt to third parties that has allegedly been dealt with. And we haven't gotten any of that. So that's why those statements in the interrogatory saying, hey, we still need to supplement and still need to figure out what all the exact details of these fraudulent transfers, because we still need to look at defendants' documents that they refuse to produce and have not produced for over 6 months at this point. And I understand that there was prior counsel who withdrew, and then it took new counsel time to get onto the case and get caught up to the facts. But instead of producing documents, they've sent requests and are trying to box us in to these interrogatories and cut us off on being able to completely look at all the facts before they have to produce all these documents that are relevant to the fraudulent transfer claim. Also, Your Honor, oh, sorry.
I was going to ask if I could briefly respond, Your Honor.
Go ahead.
Yeah, so we produced over 3,500 pages of documents back in May. Those are the documents that counsel claims they're continuing to review and need time to review. That they've had months to do that at this point. I've checked with my client. I believe, as I told Ms. Brigard this morning, we've produced all documents that we have that are relevant to their sole remaining fraudulent transfer claim. So we continue to hear these allegations of, where's the evidence of fraudulent transfers? There aren't fraudulent transfers. We haven't seen any evidence that those have occurred, and that they continue to assert without any justification, without citing to any specific facts, that there must be fraudulent transfers that occurred, and therefore they jump to the conclusion that we must be withholding documents. I'm not in possession of any documents that I'm refusing to produce on the basis of the objections. The objections are made to cover the basis, but I don't think we have anything.
Your Honor, they filed a motion for summary judgment. Sorry,
Excuse me, the objections are all overruled. You need to provide a response to those requests by the mediation. Okay.
Okay.
Anything else today, guys?
Your Honor, I'm sorry, it cut off a little bit for me at the beginning. Was that an instruction to us or to defendant?
The objection is overruled. They need to provide all the documents requested by the mediation.
Okay.
All right. Anything else today, guys?
That is all that we have, Your Honor. If
I believe you'll see us again this afternoon on a couple motions, Your Honor, but that's the 215 block.
Correct.
Okay. So just when you're preparing the order, do two different orders. The order should say that this was heard on the record over Zoom on July 6th, 2026. All parties were present. And again, it was over Zoom. Make sure you share a copy of the order with the other side. Get that to me by 2 o'clock today.
Yes, Your Honor.
Will do, Your Honor.
All right, guys. See you at 2.
See you too. Thank you, Your Honor.
All right, everyone. This is Tony, my court coordinator, court reporter, right over here. We'll see her tomorrow. We have about almost 20 interns here tonight, not quite. Tony's been working with me for the last 20 years. So
Yeah, that's right.
it's the next year or last year. So anyway.
Okay, I will see you back at 2.
2 o'clock.
All righty. Bye-bye.
And Mr. Hale, I don't know why he's still here. No. Okay. All right, guys. So let's chat. So we have a lot of stuff to cover. So we were going over these pieces of paper. I want to kind of go through the schedule with you guys, make sure they're all clear. And then at 2 o'clock, so you kind of know, this is something I've dealt with this issue since I've been a judge and an intern. And this is the best way to figure out how to do this. So there is a dress code here at the courthouse. And I know for guys, it's pretty easy. You guys all dressed in suits. But I do a little orientation for the guys on what exactly you're supposed to wear. For the women, we have done this variety of ways. We have a former intern of mine named Alexa Balderlove. She is very good at this kind of stuff, and she's going to meet with you guys over Zoom, all the female interns, to talk about what is appropriate, what's not appropriate. She's very opinionated about this stuff, and she's an associate attorney over at the top law firm, and so it shouldn't take very long. It's not this is probably summer, so but I would think about questions for the questions and whatnot. For guys, typically the only time I ever had issues with a male intern is going to be 2 interns. So hopefully you'll have issues with they feel like ties and socks and shoes and whatever. So one thing I will say to everyone is that tennis shoes are never allowed. No, never ever, unless you have a medical condition. So that is my one way. There's lets you so differently. That's one thing. No tennis shoes. All right. Okay, so that's going to be a new, but let's go through the schedule real quick. So today we have we're remote and we're going to be usually for Mondays we're going to be remote and we won't have to be here. But today you get their orientation. I think this is first. Tomorrow is our trial doc. We start our trials tomorrow. And hopefully I'll have time. I think we will to talk to you about Fort Dyer. I don't know. Right now I have 10 cases still on the docket, but a lot of them I think are going to go away. So you'll see what actually is done. So remember at this point we have 10 cases to sit down and talk. So continuation of the trial on July 8th. I don't know for sure, but we have the trial on trials tomorrow don't continue into Wednesday, which is 50-50. And you'll have that day to work on your memos, whatever else you need to work on. Except for the Team 2, this is a lunch with Jennifer King. Jennifer has probably hired more of my interns than almost any other attorney. It's a medical. She works for a firm called Kershaw Anderson King. She is they do medical malpractice defense primarily, and this is an excellent lunch. So this is you want to be really prepared for this. Make sure you know about the firm, you know about her. Make sure you have specific questions. She's been through this many times, and anyway, just be prepared. I don't know yet where the lunch is gonna be. I can text her. But we will see this farm over and over again pretty soon, so I'm gonna be aware of that. Two firms are pretty critical to the second part of the church, so this one. On the 19-2, you're going to happy hour with Sarah Courtney. I have a location for that. We'll tell you where it is. It'll be at 5. Sarah's a younger lawyer at the Catherine firm. Catherine is firm that represents the Dallas Cowboys. You probably want to get dressed up. You won't necessarily need a suit to this because it's going to be a happy hour. He's a little bit younger. On July 10th, we have a really kind of fun day. We have an in-person hearing document. This is Friday. And then we're going to have lunch with Team 2 again. All your stuff is kind of the first week. With Anna Romano and Drake Foster, who are 2 attorneys that work for the personal industry, who are former attorneys. And then at 5, everybody except for Maggie is coming to a margarita party. No, sorry, not a margarita party. The McCatherine party. And we have a margarita party later. And that is going to be at Lounge 31, I think is what it's called, at 5 o'clock. Or maybe it's actually early. So the McCatherine firm is, they're a really fun firm. I would go into that, and all of you are, everybody's invited to this. All of you are in fact, I want you to go to this. I've already RSVP'd for all of you, so let me get the exact location. It's at Lounge 31 at 4:30. My guess is that you guys will we'll have a short day that day, so you'll have a chance to probably, and I don't know what the guys will want to wear. You might want to wear suits for this, the guys, but we're gonna probably have hearings in the morning. We'll have our lunch, and then you guys can go home and kind of rest, and then at 4:30 meet at Lounge 31. Do not be late. Do not be late. All right. Any questions about the party? And I think I told all of you that the second half of summer, there are less events to go to, which is definitely the case. In June, we had 1 million, but there are a few, and this is one you should definitely go to. And I would research for all of you guys who are not doing this lunch with them. I would research the firm. I will tell you that I've had interns who've gone to this happy hour who have been hired as attorneys later because of the connections they made at this happy hour. So I would go in being prepared, ready to have fun, but also know a lot about the firm, research Levi, research some of the other partners, and just be prepared. This is an opportunity for you guys. You'll be joined by a few other UNT students from this June, Mary House, if you know her, Annie, and who's the other? And Shaylee, Annie and Shaylee. So they're also going to be there. So anyone have any questions about the party?
You said where?
No, I said just you don't have, you can wear a dress. You don't have to. You can wear a suit, whatever, but it's a little more casual than before.
Okay.
It's just for guys, you don't necessarily have to wear a tie to it. But you probably want to wear like a sports jacket or something like that. On the 13th, let's start kind of talk about that. We have remote hearing docket. All the interns were remote. And then we're going to lunch with a guy named Brian Hoffman. Let me tell you about Brian. So Brian is a tremendous product. I've seen him in trial. He's probably one of the best I've ever seen. He was extremely high. Extremely high. Very, very fine. Very fine. Very humorous guy. The jury's absolutely like him. I'd say he's one of the best lawyers I've seen in trial. He is one of my two of my former interns were two associates. Two of the students. I would be very prepared for this. Brian is the type, I don't really say it's really predicting, but I'll give you an example of something he did once. And this is not something he did. But I was at an event with him, I had a couple of interns, and I said, well, Brian, you did something. And because there was one there that was really good. And I said, you know, I think that's would be a really big issue. And so he came up to him and said, you want to work with me? And she said, yeah. And then there was another intern sitting next to her, and he said, she said to her, you want to work with me too? And she said, so they both got an internship just by being up with that. I have no idea if he'll do that with all five of you, but Brian is kind of like shooting kind of guy. He's a great lawyer. And I'll figure out where we're going to lunch. He'll probably bring some of his associates with him. Anyway, good place to live. Good, very good. On the 14th, we have an in-person trial docket. So this is one thing we kind of play on the logistics. How many people here have been our system? Excuse me, not maybe less. So the RCC convention is where the Dallas Bar holds your meetings. It's a very nice venue. The BBA Business Innovation section, I am the chair of that this year. Holds an annual or monthly CLE. This is going to be the monthly CLE. It's going to be about jury charges. It's going to have two of the best appellate lawyers. Rick Morgan was also, you know, we're going to have to figure out a way to get from here to there. And we're glad to be able to put all part of the best possible. So you guys probably want to figure out, we can figure out layout, anyone has to do, but we're going to have to get from here to there and then back. And so it would need more car. But it's good more that's problem. So on the 15th, next week we have a special setting case. There's usually tend to be bigger cases, so I think we can follow the school systems. So the 15th we have going to the gallery firm. The gallery firm just hired the first off third. Who you guys know is working together the summer. It's just been growing very quickly. Young community y'all in the 30s. And part of the firm does civil, part of criminal, the civil part is growing very quickly. And so they are looking to hire interns. So we're on to list 16-1 is on the 16th, we've got much notice to do. Department of Vegas, they fired some she's a former. That'll be at noon. You know, with more detailed stuff. Then after that, or in the evening, have the DOI wine tasting. At Constant Self. I have not largely grouped off for this, but I will assume everyone except for Maggie is all good. We want not. What? You don't have to drink, but I don't think so all right, so that'll be a lot of fun. And on the 17th, we have breakfast with Amy Stewart. And it's gonna be a little bit different than our other ones. We have Jeff, Cinderly, Vivek, my big, Zane, we're not going to that, only bring, only bring 16 points to it. Because Amy wanted me to bring your number, because she had so well. Amy Stewart is a very good commercial insurance coverage attorney. And a very, very smart. And she knows never and she wanted to have so she's hopefully funding issues for us, so that should be good. They also have folks there that have one of my first factors. So it's good. That's on the 20th, and this is where we usually would have all this worked out. This we tried to meet with that December. This would be the first time maybe what I imagine will happen is that you guys would let me know, okay, and this is your opportunity, guys. This is so let me know if there's a firm that you're interested in, a type of law you're interested in. You know, maybe give me a list of firms. I can start setting that more with some flexibility here. But I'm leaving the ball in your court, so you have to do some research here. Something you're interested in, I can help you with that. We have some good dates here, so that's one of the dates we can set stuff. If not, if you guys don't get back with me, my other goal is I would like to do a lunch with each of the teams. This maybe on the team, so maybe that's what we're so if you don't have that, 21st is the same way. 22nd, 4 is one to lunch with LGZ. Andrew's a solo attorney that used to work for me when I was a lawyer for many, many years ago. He now has his own law firm. He's hired a lot of management here. If you think that you want to work in a lot of different areas of the law, he's worked like that's how he's really done with things in place. It's like almost like a general practitioner. It's hotels that you it's criminal cases and family cases and probate cases. He defends people in defamation. This has had a little bit of everything. He is very interested in document cases. So he doesn't pay very well, but he does a tremendous amount of schooling. That's how it works. He was for 23rd is when only was open days. On the 24th, we have team 3, which are you guys. We're going to lunch with Bailey Wang, who's a former intern of mine. I actually kind of lost touch with her until recently, and she is at a point this firm, which I don't know anything about them. She told me this. So this is the first one. So hopefully that will go well. And she says that kind of fun. So hopefully this will be good. On the 20th. So anyone have any questions so far?
So for the winters remote day, all interns remote, we all went logging to Zoom off.
That's a good question. That should yes, you'll all want Zoom. Couple rules about remotes. Okay. Understand what's in the don't look at remote as this is my day. You want to focus on the time. So you have to keep your camera on at all times. You have to be really formal. So I will tell you that I use it like a tie on and then sweatpants, so that's fine. But you still have to wear a tie with the camera on. When you change your name from the but if we span a circuit or we plan a circuit, comma, 60 will get you pulled into it. We might end up asking, why does Judge Hoffman do that? That seems kind of weird. Because there's so many of them, and whenever somebody joins the Zoom, they want to know who else is on there. And if they see all these people, they get their view. So this is important thing. So keep your camera on. We were there, for all the hearings, and quite mentioned, I know it's hard to pay attention on Zoom with this year. You can learn a lot from Zoom, does that make sense? To what you're watching? It's always with the same Zoom members on the, what, that's the.
Single question, other question, so, I don't know, now it's the primary, but we're out there, but I'm looking for sports now, in small.
Okay.
So, I don't know if it's really.
Yeah, I think that's something to do. We need to,
I know Levi's covering, that is what the Cowboys is, but.
Levi would be a very good fit for that too. That's, yeah, Levi is one, but there's are you talking about sports agent law or? Okay.
Yeah, but I mean, really.
What he does, he's not really a sports agent. He represents like the Cowboys gets Jerry Jones. Jerry Jones would sue, Cowboys would sue, Cowboys players would sue, or they've been a lawsuit. He represents Cowboys. That's not his only job, but he represents all things. He's basically like Jerry Jones. And the firm itself is, and I don't know if you will talk to him but the firm is very, it's very fun on the real life. Parties, it's very social.
That's not for, actually, that's why it's here, different consider, Sarah Courtney.
Oh, that's right, yeah, it's exactly. All right, so, the 27th, we have a new lunch with Jamie DeWeese. We just said that we might mention two more, and she is at King Russell. Their firm hires concerns, they're probably the most challenging firm in terms of like grades and that kind of requirement in law school of all the places on here. Team one is going to that. For the 28th, we have an in-person trial document, and then in the evening we have a margarita party. The leaders at Chris Anderson came at their office. So you guys will develop some relationships hopefully with that firm, but you guys also will have an opportunity to understand what the, and let me just give you some general advice on how to approach all of this networking or this networking generally is, and I believe I can Captain actually did the best job of her explaining this. Hopefully this was sometimes. Yes, I hope it was. So let's say you have a problem. So let's all right, you got to do this first. Hey Alexa.
Hey Judge, how are you?
Good, I'm so sorry. I was chatting and I forgot. Sorry. But the interns are here. You guys, all the female interns, you want to come over here so she can see you? Alexa, you doing okay?
Yeah, I'm good.
So Alexa works at Dorsey, and I'm going to take all the guy interns so you can see, try to let her see you here, or I can, or you guys can sit over there actually. There's not that many of you. So, there you go. All right, Alexa, you guys, can you see everyone? Alexa, can you see them?
Yes, I can. Thank you, Judge.
All right, I'm going to take the guys with me and we'll just try to get, Alexa, can you try to keep this within 10 minutes?
Yeah, of course.
All right, thank you, Alexa, for doing this.
Mm-hmm.
Hey guys, come with me.
Okay, can y'all hear me? And are they out of the room? Okay, I can't really hear you guys.
you hear me on this?
No, not really. I can like there's an echo. Um, that's unfortunate because a lot of this is kind of like dialogue. But I think I've met maybe one of you if I remember correctly.
I think we met at the fundraising.
Yeah. Yeah, I was about to say you're the one who looks familiar. But hi everyone, my name is Alexa. I don't really like turning on my screen when I'm on Judge's big screen because I feel like it's just so weird. I'm happy to, that way you guys can see my face for a second. But I feel like I'm talking to nobody. But real quick. Hi, this is me. I'm turning it off because I'm not gonna be here like this all day. Okay, so just a quick, I guess, 10-minute overview, and I really like it to be a dialogue. So if y'all have any questions, just feel free to like shout in. But I'm really just here to talk about kind of what's appropriate for court workwear and what's not as appropriate. Um, I think everyone, from what I can see, looks very appropriate today. I think, in general, try to just wear, unfortunately, like the darker clothing, not like a hot pink blazer, no bright orange, lime green, things like that. Like try not to stand out. I do understand that we live in Texas, so it can be extremely hot. So I don't think a blazer is always necessary, but always cover your shoulders. I do think if you're meeting attorneys, like Judge will take you guys to a ton of events. Um, I think when you're meeting attorneys, having a blazer on is better just because it is kind of like that pre-interview. Whenever I was an intern with Judge, I did get a job from one of the lunches that he took me to. So just keep that in mind. Like these are pre-interviews. Always keep, like either pants or skirts, dresses are great, but if you sit down and I can see up your skirt, that's probably too short. Try to keep it modest. Um, I know Baylor Law School always says like pantyhose is required. I don't think that's required. It's if you guys are comfortable in them, wear them, but they're not they're not needed. And I think in Texas it's just an added layer that's unfortunate that you guys don't need. Um, and I think I'm trying to think of like other just random things. I know whenever you're meeting attorneys, the slingbacks or like the open back mules that kind of sound like flip-flops when you walk in them, attorneys do take note when they hear you coming. Like I cannot tell you how many times someone has told me like, "Oh, I can hear her coming," and it's not a good thing. So when you are meeting attorneys, try not to wear a slingback or an open-toed or an open back mule, just because if they hear a flip-flop, it can, for whatever reason, it drives all of them crazy. So I would try to keep it closed-toed, always closed-toed, and like a closed back, if possible. Um, I think patterns are okay to wear as long as they're not like super crazy bright. Again, like try not to wear like a bright pink shirt that has like a crazy pattern. You don't want to be standing out. Do y'all have any like questions specifically for me?
I do have a question.
Oh, I can't
So
really hear you. I'm so sorry. Someone go up to Judge's place and just tell him it's on me.
It can you hear me now?
A little bit better. Keep going.
What about now?
Yeah, I can hear you much better now.
Okay, perfect. What are your thoughts on like earring stacks? I am been trying to keep them really subtle, but I do have piercings and I want to make sure that that looks appropriate and like jewelry in general.
I think jewelry can be appropriate. I think earring stacks is okay. I wouldn't do like a full ear. I don't know how many piercings you have. Um, but I do think jewelry is one way you can make your outfit a little bit more personalized. In this, because you don't really have a ton of ways to like make a black suit look super fun and unique to you. So I think jewelry is a good way to make your outfit a little bit more unique. Like I said, I wouldn't do a full ear, but I think like two earrings, like a two earring stack, three maybe depending on the earring. But I wouldn't go past three, I don't think. Any other questions?
Yeah. Can you hear me if I talk this loud, or do you want me to?
No, I can you can try it and I'll see.
I'll just go over here. Okay, so can you hear me better now?
Oh, yeah.
So related to the like they can hear you question or comments, does that also apply to just heels in general? Like should you just wear flats so they can't hear you coming at all?
See, no, I wear heels all the time. Everyone wears heels. I don't know why it's the flip-flop sound that drives
Okay.
people crazy.
Alright.
The heel I don't think bothers anyone, but I have had numerous attorneys talk to me about the flip-flop noise. I don't know why. That specifically is like whatever irks them.
Okay, good to know.
Mhm.
You guys have a question? Take a moment.
Any other questions?
I guess I do have one.
I'm so sorry, you'll have to keep running up.
Are there any like hairstyles? Like I know there are obviously like some obvious ones, but like ponytails or like if I wore like for instance, I have naturally curly hair, so I'm not gonna always be able to like blow out my hair. Like is like a flower hair clip okay or something like that, or should it be something like very? I should keep it very basic and like.
Um, I don't think Judge would mind a flower hair clip, but I wouldn't do it if I would just say no. I would try to keep it more professional, than a flower hair clip. But I mean, ponytails are cool, buns are cool. I wouldn't do like pigtails, but that's just
What about somebody's asking about a slick back?
Oh
Like,
yeah. I mean, on my fourth day of not washing my hair, I'm definitely in a slick back, so
thank you. Oh,
yeah.
just give me your questions. I'll just like
Okay.
people.
My only question is about like perfumes and things of that nature. Because another thing that I was thinking of, some of the industry heavy solution.
She's asking about perfumes. Like, are there any like limitations as to how heavy or light they should be?
I mean, again, I think that's a personal thing. Some people don't care, some people do care. I think if you're meeting people, I would try to keep it more subtle than, being in their face because some people have allergies and you don't want to. I just don't want you guys to turn off someone from an interview because of perfume. Even if it smells delicious, they might not think so. Um, and I would rather you guys just have more opportunities than not, if that makes sense. So I would keep it subtle.
Pretty good. Yeah. People ask why you get to wear a dress versus a suit. Don't have something to be. And there's no length of the dress.
Okay, they're asking, like when is it appropriate to wear a dress or like versus like a suit at like networking events, and like how long or short would you suggest? If so.
So I think suits versus dresses. I think if it's like, a happy hour or something after work, I think a dress is totally cool. I mean, you guys are gonna know if it's like a DBA luncheon, I would wear a suit, but if it's a Dorsey and Whitney or a McCatherine happy hour, wear a dress. Um, I think if it feels more like a bar association, then maybe wear a suit. But again, I don't know how often y'all are in the courthouse. Um, and if you have so many suits that you won't run out, that's awesome. But you'll eventually run out and want to wear a dress. And I think as long as you have a blazer with a dress, it's totally cool to wear a dress to luncheons or other, you know, events. Because I wear dresses all the time and other attorneys wear dresses too. The only time people really wear suits is when they go into the courthouse. And as for length, I really don't, I hate commenting on that because I feel like I'm back in high school where like it's got to be right at your knee. And we're all so different, right? Some people have longer legs or shorter legs, longer torsos. Um, so I think if the whole thing is if you put it on and you're gonna question whether you think it's long enough, the answer is probably it's not long enough. If you're asking yourself like, ooh, is this a little short? The answer is probably yes. Um, Again, if you can sit down and feel comfortable in it, then I think it's an appropriate length. If you sit down and you're like, oh, there's a little too much leg showing, then I would say it's too short. Does that help? Any other questions?
I just have like one more question. Like as for colors, like I know that like this one's like like neutral, black, beige, blah blah blah. But like, could you wear like a top hunter that's like, or like whatever, like that's like a dark green or like a light blue, like nothing, not like a crazy color like hot. Those sorts of colors is that also looked down upon or?
No. I mean, some attorneys, I think the older attorneys would, want to just wear dark colors, but the younger attorneys, I have like a tan suit that I wear to the courthouse all the time. I like baby blue. Um, I think like those, they're still subtle colors, right? And it's also summertime, so I definitely season wear. So like I match my colors to the season. And if you guys do the same thing, then you would want to wear a baby blue in the summertime. Um, so I think like those colors are perfectly acceptable.
I think we're all good with questions.
Okay.
Someone's asking, could you recommend brands for flats?
What are flats? Pumps or flats?
Brands for flats.
Oh my God, I'm still missing that first word. Say it one more time.
Brands for flats. Like, do you have recommendations for like where to shop?
Oh,
for
like
flats?
what I would recommend for a brand of flat.
Yeah.
I, oh gosh, that's gonna sound, I wear loafers all the time from Sam Edelman. Those are like my go-to flats. They're so comfortable. Um, Other flats, I don't know if I have like specific brands, but I just buy them from random stores. I can text you guys the stores. That way Judge Hoffman doesn't hear where I shop. Good, how are you?
Well, thank you for doing this. Was that helpful, guys?
Yeah.
Well, I see you're always so kind to do this.
Yes, of course, happy to help.
You decided you wanted to read your folks next Tuesday?
I have no idea. Judge, it's so hard to hear you. I'm so sorry.
Sorry.
That's why we like.
No, that side gets worse. I need you over at your spot. Yeah.
Can you hear me okay?
Yeah, I can hear you better.
Oh, I was just, guys want to bring your folks on Tuesday, next Tuesday?
Oh yeah, I'll talk to my office manager about it and let you know.
I'll try to let you know more about the trial, but it's a special setting, those tend to be pretty good trials, so. Anyway, but just let me know one way or the other. And are you coming to the business lit meeting?
When is it?
I think it's also next Tuesday.
I should be able to as of this moment, yes.
Okay. Well, anyway, let's give Alexa a round of applause. Thank you, Alexa.
Yes, of course, Judge.
Thank you again. We really appreciate all you're doing.
Of course, bye.
Bye-bye. One of the other things I like to say, and I think was really true, Alexa's a good example of it. is that part of what I do here is try to get back, this is my way of giving back, and very, I feel very blessed to be a judge and be able to see everything I do. But sometimes it's great when you guys also give back. So one of the ways you're gonna be able to give back is, when the guest returns all start and Maggie's gonna be here, you know, want you guys to go to lunch with them and kind of share your wisdom about how you got to law school. And what did you do for everybody else at? Why is Baylor and UNT and UT and why is that the best law school to go to or not the best law school? What are some things you learned about the first year of law school? So that's your way to give back. So, Alexa has been doing this for 3 or 4 years, which I wasn't sure. It's hard to figure out how to tell these other interns. I don't want to tell them that this was better. So Alexa's been so kind. So she doesn't have to do that for some work. So, all right. So how far? Where will we in the margarita party? Margarita party, yes. The margarita party. Oh, okay. Oh, yeah, okay. Okay. Okay, so let's go through this. I'm gonna finish this up. So the Kershaw Anderson party, again, this is a great way to meet people. Kershaw Anderson will be the memo competition. Anna Romano has got a group of attorneys who you guys are going to lunch with. No lobbying her for being the best one of it. So you're going to be seeing that growing quite a bit. And things at that firm. So this is a great opportunity to meet people and stuff like that. And then for the 29th to the 1st, so Wednesday, Thursday, Friday week, I am going to be gone. And so you guys will have an opportunity. Just let me know what you want to do. At the very least, if you had a trip you wanted to take for a few days, you have doctor's appointments or things like that, try to schedule it during that time if you can. But that Friday, we'll probably have a hearing document in court, handled by the appointed associate judges and talking about the communities further. So you might want to at least attend that, but can also will come when you want to turn so anyway, let me know if there's something you want to do. I can also find out if there's any criminal trial, if there's a criminal trial, you know, I can reach out to so we should do okay. So if I do this, just let me know, kind of think about that. You know, I can decide on you know. But I don't want you to just be bored or you know, I think you more after your first year of law school, so I'll be gone from the team. August 3rd, we have a remote hearing docket. Again, that's another day we can schedule other stuff. On the 4th, we have an in-person trial docket. We had something else scheduled. Let's see. What day is that? Oh, I'm doing a wedding now. So this next thing, no one has to do this, but I've had interns who wanted to do this. Some of you guys are from San Antonio. I'm going to be speaking at a state bar conference in San Antonio on the 5th and 6th. Who's from San Antonio? Come on, you're from San Antonio. So if anybody wants to go to that, and I'm not paying you travel or anything like that, but if you want to go and you want to come watch me and I'm going to do a ton of attorneys that are still not working, you let me know, especially if you have family that you can stay with. I had no problem with something that people in the bar community here know about me. They make fun of me about it. Who I am is I try to give you guys as much stuff as possible. And so I would either one who says, hey, can I bring my for this? And sometimes they'll say yes, and they'll say no. And so if you are interested in coming to that, let me know and I'll make sure I can get clearance.
Do you know where the equipment is? Or?
It's a really nice little, maybe Highfield Country, I think. No, is that in San Antonio?
Is it the one next to the studio?
Yeah. It's really nice.
The insurance part, I go.
Okay.
Yes.
So kind of, speaking of, person is, so it's cool. I've been talking a lot about this new system of judgment rule that I hate. People don't like it, so I'm speaking about that. Then on the 7th, we have an in-person trial docket that day. Then we have on the 10th, we have the Friedman Feiger, Jason Friedman, who you work with. So you're on team 3, so this works. And you want to tell them a little bit about the firm?
Yeah, they're a great firm. They do commercial litigation. They're located like North Texas, or North Dallas side. And I mean, they were great people. It's not busy work. It's very like motions and facts. I think to be within that month. So it's you get to see your work, actually come to fruition as an outdraft. Discovery deficiency letter, and the next day, like it's emailed to the client after what you do obviously. So it's really a great firm instead of like being your boots on the ground with kind of experience. So I had a great time,
And 3 of the 4 firms is some confidence.
I don't share these there.
Yeah, they are a great place to work in team 3. The 11th, we have an in-person trial docket. On the 12th, we have a lunch. Right now, it's with team 3 and 4. It might end up being more. Sean wanted me to invite all of you guys. I don't know that that's I want to, but we may end up all doing that lunch. He wants to do a presentation about his farm. So this is one you do not have to. You can if you want to. It's a personal injury farm. Prepare a question, but I don't consider this as one of your individualized programs. And then on the 13th, we have the jail Bedford lunch. Jeff and Cinderella, but that. And then the 14th is our last day. I imagine that on the 13th we'll probably be with intern deputy, and depending on time, on the 14th we have a prediction that we didn't get to do the rest of the summer, but I'd like to hold on to it. But we do a ping pong tournament. So, how many of you guys are really good? You're good at ping pong. Okay, all right, you're good at ping pong. Okay. And what we usually do is we have like boy and girl teams. By then, we'll have some more female interns and guest interns. So we usually try to do boy girl teams. And nobody ever picks me for the team culture. But I end up being on one of the teams sometimes as well. So at some point during the time that we'll have a job with people. Does anyone have any questions or any comments and thoughts?
We separated, we were on the margarita party topic. We're going to give us advice on networking.
Yeah. Whenever you go to those, to either the Catherine party, this is especially true. Oh, now I know what I was going to say. Yeah, this is pretty right when Catherine said this. So I have it, I'm not going to use it. This is exactly it. I have 2 interns. One that in Farmland, you would probably meet, who I've stayed very close to, who wants to the courthouse, and this is doing school election. And another attorney. So they and Levi was talking with them, this is and he said, hey, Bob, and Bob wasn't doing research. He knew what was doing. So he said, how many of you needs litigation or insurance defense or health? And that firm did all of those things. He asked Amy, what do you want? And she said, and I told her not to do this. So nobody knows. And that firm did not do that. And so I asked Levi, kind of in front of him, because I just wanted to see what he said. I said, what do you think of their response? He said, well, I like Farboff. My firm does that. And that's part of my practice. You could help me. But we don't do bankruptcy law. I'm not going to create a bankruptcy section for somebody who has a problem loss. So she's kind of eliminated herself from any type of opportunities. So I know a lot of people in the generation, not a criticism, are like, I don't really know where I want to be. Other people are kind of in that situation. You don't know. This is how I try to describe it. I don't know if it kind of resonated with before, so let's see if it's works. So, let's say with that, you should be early. But who knows who does so you were Nicholas. Yeah, that's not sense. And then when you are graduating lost, would you rather have 5 opportunities that weren't perfect or no? They're not perfect. Okay. So how do you get 5 opportunities? You don't do what Amy did and tell people, I only want to do this when they're from this. What works better is if you're going to a farm and you know they do, like the Catherine does, some commercial litigation, or they do a whole variety. And you kind of look at what they do. And they ask you what you want to do, what do you tell them? I do what you do. And don't just say I do what you do, but know what they do and then say that in back. And we had a whole discussion about this. I actually had a discussion. And you know, it doesn't necessarily have to be exactly what they do. Like if you go to a lot of these firms only do software. You know, if you say you want to do transaction, you eliminate. So I know it seems kind of bad. You're like, well, I should just tell them what's in my heart, right? No, she said no. Right. So that example.
Yeah, you said I'm here for that. So I had an interview with my nurse saying, this is like when I first started law school. And they were interviewing for real estate. Right? That and I told them, I don't know what I want to do, but I'm first to law school. And they're like, no, but when we're deciding between 2 different people, we want the person that wants to do what real estate with them. And so they're like, just tell me what you want to do.
Well, at least they were honest with you. And that's true. I mean, otherwise you're going to be, you could be in a situation with your opportunity. So you know what the firm does. And sometimes it's tricky. I'll just say this. Sometimes the firm is like, please Smith is a good example. They put on their website that they want to do commercial, they do intellectual property. That's really not what that firm does. So everything else in the firm is about insurance defense. Don't just pick one thing that they do. Check and see what the partners and other people there actually do. You get better idea. Commercial, for example, agreement fiber. What percentage of your work is for? How about what percentage can? So that firm technically does OCA's law, but if you look at the partners, so just kind of be aware of that. Do a little bit of deep dive. Does anyone have any questions about that? That everyone's a little bit. Okay.
So if there's a necessary commercial litigation.
You don't want to be commercial.
Technically not. I don't think it's just. So in that situation, we still advise 90 people that work with them and
you have like why don't you? That's when you get we probably be very lot of viewers. I mean, I will say this in context of what we're doing here. maybe I should switch you to a different team, because I think your team is much more focused on commercial litigation. So maybe I should switch you. I didn't realize that. Does anyone want to switch?
What is my team?
Personally.
Because I'm working personally to some.
See, what team, your team 3 and your team 4, so you're closer to team 1, so we see what see what's team 1. Alright, it's your places. Have you already started working on it?
Yeah.
Okay, go ahead. We'll keep reminding some. We're not doing this for everybody. I'm sorry, we're not gonna do this. Yeah,
I'll make it 3.
We're not gonna get to it. You know, actually.
What is the
Team 3, let's see, commercial, personal, you're kind of the mix. We have commercial and personal injury and personal. I put him on this team, right? I wouldn't normally put this team really having the freedom fighter lunch because you're there. All right. I don't know why I did that. So, all right, no more shake. Any other questions? Good.
But I don't think.
right here? You want to do that?
That's the first one.
Yeah.
That's-
Okay. There's a reason I have this kid story. So, I'm gonna let you guys work this out yourselves. If you can figure out a way to have a guide here on this team, I want this team to nice. Don't trust your nothing. So, but you have the Brian Lockley lunch, which is actually a really good.
I don't really want commercial inclusion. I just don't want. That's right. I worked there this summer.
Okay, all right, we're gonna change subjects, okay? All right, sorry. It's not even said anything, okay? Everybody's gonna get to do everything. We're all gonna do it. So, any questions about that?
You said I could go to at least one networking event.
Yeah.
Do I get to choose which one, or do you have any recommendations?
Let me see. Where do you want to go to law school?
I do like commercial. The McCatherine sounded really interesting. It's like Sarah Courtney, but I don't know if there's.
Yeah, Sarah, well, she went to TAG. Okay, well, that's a happy hour though.
Or the one,
Is.
We'll chat later. Okay, let me teach you the next thing we need to learn before tomorrow. We have to learn before tomorrow. We're gonna teach you all about board audit. Okay, and there's a reason. Did I do this before the board audit thing? Okay. All right, I love how you're enthusiastic. We're gonna do this. We're gonna do board audit. So let's talk about board audit. And there's a reason I'm doing this right now. This is one of the things that will definitely be on interim. And I hate to do this your first day, but we have to do it your first day. Because we're going to be doing some math. And I know people don't like math, but that's just the nature of it. Okay, so let's talk about jury selection. Jury selection in Texas. Some of this will be more simple for some of you, some of this will be more complicated, but it'll get more complicated. Jury selection in Texas is not a process of selection, it's a process of deselection. Okay?
Yeah, you have a nice, I can see that.
Yeah. Good. Is that okay? Yeah. Okay. The process of deselection, not selection. So that's the first thing that I'm doing. When you are, I think some states are a little different about this. In Texas, we have select jurors and deselect jurors, and the jurors who are left over, those who would go. So that's the first thing you have to point out, jury selection. So, typically in Dallas, a district court in Dallas County, which we talked a little bit about this. There's a difference between district courts and county courts. Typically, in a district court, you have 12 jurors. Typically, in county court, you have 6. So, typically, in almost all cases, in district court, you have 12. In most cases, you have 6. So, how do you get to those 12 jurors? How does that work? So, you will go through a situation where the jurors will be walk through how this works with this. In Dallas County, in most cases, the jurors are summoned to the central jury room, which is downstairs. You walk by and the security, and then they are put into panels. Typically, in typical civil district court, we're talking about that. It's usually a 40-person panel. It's when the is kind of important. A smaller panel. They'll be set up here to be lined up by the bailiffs, from the bailiffs in here to be seated, and we will start the process to do this. So we're going to kind of go through some 2 tracks. How practically does this work and how does it work on the legal side? So you guys are going to get out of job. Okay, part of your job, and you probably put this one, is you're to assist Gary and me in the process of bringing jurors. So first thing you're going to do, who wants to volunteer?
Okay.
All right. Secondly, Michael, you are. What? And then we'll have 3 more volunteers who will bring jurors. So Hannah, Rep, and Say, you guys are jurors. Okay. All right. You guys come over here, you guys can jurors. Jurors come over here. So I want you to visualize this. We're going to have 40 people outside. Gary's going to line them up into rows. Okay. And the number one thing I'm concerned about in this process at first is to make sure that the jurors sit where they're supposed to sit. And you might think, well, that seems really easy, right? Like, how hard is that to get people to sit in the right spot? I understand a lot of these jurors have never been to a courtroom. They have no idea what they're doing. Sometimes they wander off, even when they're lined up. Sometimes they get out of order. Sometimes they go take a phone call. But I have to make sure that everyone is seated exactly where they're supposed to be seated. Because if they're not, then the whole process could be messed up and we try to stay. So this is based on years and years of experience. I do some things. You guys know belt and suspenders. Here's what the term is. That you're basically doing 2 things when it's something. You don't need a belt and suspenders, but for both of them, you're keeping the class. Maybe the belt belt, maybe suspender belts, with the other. So there's things that Gary does to make sure they're in the right order. There's things I do, and there's gonna be things we do to make sure that you're the same. So as they come in, you guys go ahead and line up over here. Gary's gonna line them up in order. You look up at this chart here, you can see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Jurors 1 through 6 are right here, 7 through 12 are over there, 13 through 19 over here, 20 through 26 over there, etc. We need to make sure that every juror is in the right spot. So Gary lines them up, usually all in order. And I will say without one vote before trial, something happens. But when they start, when they have a substitute day, then it's over. So you bring them in. You're going to be juror number 1 in the circle. Okay, that's what you do, right? You give them juror number 2, Zay, and I'm not. Okay. You're going to be my mentor assistant, right? Your job is to stand right here, okay? And as they're coming in, you're going to be pointing them in the right direction, right? So the first 6 jurors go this direction, the next 6 jurors go in this direction, and then come up to here. The first 7 jurors go in this direction, and the 7 jurors go in this direction. And as you finish the row, you stand up, you move up. Point in this direction from the last row to the yeah, we point this direction. That makes sense. Alright, so you get right here. Does that make sense?
7, 6, 6, 7.
7, 7, yes. But what you do is you do 1 through 6 here. So the first row we remember. And so really kind of circling your number 1. Whenever you have something, you're number 1, you're going to be violated. And what are you doing there? Nope, you're not. I wasn't. You do not speak during this process. You are silent. If they say anything to you, you just point to them to the judge. You are 100% silent. Because I'm the one communicating with them. You get enforcing my communication. You are standing like that. Okay? Not like this. Okay. So we see the first 6 jurors, and will be the first 6 jurors, and then we start with juror number 12. Now, why do we start with juror 12? Why? Yeah, exactly. It's 12, 11, 10. If we started with 7, it has to go around each other. So the next year, you're going to be juror number 12. All right. 3, 9, 10, Zay, Jim, Zay, Jim. Zandu and Zandu. Very Zandu. Are you, sir, Zay, yes. You're going to be juror number 12. All right. And then you're going to be juror number 13, Jeff Razor. Where Jeff to go? Yeah, okay. So what do you do at this point? You're going to the next starting group. You step up, okay? We Jeff. It was the same way. Does that make sense? Okay. Daniel and Mark. Yes. All right, does everyone understand what your job is? It may seem silly, but you're helping make sure it's possible. Does everyone understand what your job is? All right, what if the juror says to you, hey, I don't speak English? Point to the judge. Do not engage them in conversation at all. What if you say, I have a comment? One to the judge. And then you're not going to do it. That makes sense? Are you guys all sit down now? So that's the first step. We want to make sure they're seated in the right spot. What will happen next is I will give a little speech. You'll notice the speech is fairly similar to each time. I hope you'll kind of mix it up a little bit. I'll give a little speech and go ahead. And then I turn it over to the attorneys. So the attorneys will each do a presentation where they ask the jurors a series of questions. And they talk a little bit about the case. And I can teach you a whole class about what makes good board argument, bad board argument. One of the things we're talking about during this process, during the course of the internship, is what is what are best practices, what are not best practices. But for their each individual. So we talked a little bit about the process of these things. Why are they asking questions? We're trying to figure out issues of products, approaches involved in this. So let me give you kind of a quick little test and see how you guys do. So if you're doing a personal injury, let's say who's the attorney? Sally, you're the attorney. So you take Sally's case to trial. She has $5,000 in chiropractic care. You're asking for $1 million. The other side is from who's going to be your, we'll have Maggie. Maggie is committed, and Daniel's a lawyer. Maggie was drunk driving. He was us. She was drinking some of the white claws, had issue whereas so. As the plaintiff's attorney, what kind of bias issues you might be concerned with? What would you want to point out? Why people may be biased against this one? Now, not about this time, that would be a bias for her. So it's your conflict bias issues.
I think so she is tired.
Have you seen this before?
I work in, yeah.
Okay, so you kind of know. You may have to take it, but, okay. So that's very good. So may I ask you about mental language? He's asking for $1 million for $5,000 in medical.
I would like ask if they have any moral judgments on drinking.
No, that's what the defendant would ask. Yeah, and definitely to the lower legal defense. What are some other issues? You kind of touched on the phone. That's something, yeah, that's something both sides can ask. What are biases? That's something.
I also read that's kind of asking whether people.
Exactly. Or I guess your generation doesn't have a set of bias. My decade, but it gets tired. So it's chiropractic treatment. What would be things as Daniel you'd be concerned about being biased about?
Some of them have been mentioned, says, and so I think I feel those things. But I've been at some associations of health, especially with marijuana, I would want those, for that, I'll come up and take this.
Exactly, those are both things. You're trying to discover biases that are related to you. Okay, so they're going to be asking questions. Sometimes they'll be really good. They'll also be talking about further proof, looking more about that. But they're trying to figure out issues of bias. So how does that come into play? What'll happen from a practical standpoint is once they finish their presentation, I send them to jury council. When you guys have a new job, when you send new volunteers, you don't say volunteer doesn't volunteer. For that, you make a great cake here. And you guys will. You three go. Okay? So this is the most important job that you guys are doing. Ava, you want to go first? Okay. So what's going to happen is we're going to send all of the jurors outside. I'm going to be talking to the attorneys about which jurors they want to strike and which jurors they want to bring back. From a practical standpoint, what we want to make sure is that none of the jurors come in while we're having a discussion, because what could happen, we can have a miscount, or that jurors would have to be excused because they overheard something. So your job is, to hold on to this bar right here. Hold on to it. Okay. You don't let anybody come in. If they're, you don't let any jurors tell you to come in. You don't want to. You just put it at night. You hold it. You make sure nobody comes in. And so you're the designated intern to do that. The entire time that we are from the point where we send them out to the point where we're finished with start doing the trials, you are holding on to that. But you want to make sure nobody comes. That makes sense? All right, so this job is a little more complicated. So the first thing, you're holding on to that door, you're making sure nobody comes in. It's no jurors coming. So what will happen next is I'm going to come up with a list of jurors who will be coming in for additional questions. And this is where you dive into a lot. So we're going to let you guys play with it, okay? And we're just going to kind of go out there. The way this works is, let's say we're bringing in jury 3, 6, and 9. Then I'm going to tell you, Gary's going to go outside and look at my work. He's going to go outside and make the line come up. And then you are going to tell them, hey, you need to bring the juror in before. So why don't you go outside? All of us. We'll open the door. Have one of you guys stay. So the job of the second intern is to stay in the little alcove. So you're going to open the door and you're going to say, we need to turn everything. So you're going to tell them outside to bring them to them. Correct. And as soon as your number 3 comes in, you immediately close the door. Then you guys, we'll direct them over here. I'll talk to them, blah, blah, blah. The party's going to talk to them, and then we're going to finish the journal here. And then journal brings in. Your job is to open the door, and as soon as he leaves, close the door down. And why do I do it then? Because I need to talk to the attorneys again about, hey, are we striking this juror? We're not striking this juror. We need to have that conversation. And the next juror who's in line is not allowed to do it. So that's why your job is so important. Is to open and close that door quickly so we can move these processes. Does everybody understand this job? Okay. Now we're going to get to the heart. Okay, so let's talk about the law. So when you're striking jurors, there's 2 types of strikes. There are what are called peremptory challenges, and there are strikes for cause. Peremptory challenges and strikes for cause. So, what is a peremptory challenge? Peremptory challenge is a challenge that each side can make that for basically any reason they want to, other than a improperty. Usually race, ethnicity. So you cannot strike jurors based off race or ethnicity. It's got a text from that firm that's looking for lawyers and they want to hire a bunch of them. So, let me guess who's finished. You guys say that. So, peremptory challenges. So, peremptory challenges can be for any reason. Each side will get a district court will get 6 strikes per side. Peremptory challenges that is defined by this. So, and then for challenges for cause, You can make as many challenges for cause as you can. It's up to the judge to make that determination what the challenge cause. Why would the judge cause? Number one is that a juror is so biased that they cannot make a decision based on law and evidence, but they make a decision based on something. So, let's say that you, an example is, let's say you don't generally like money. It's probably not the thing. You think that's that alone is not destructive. What if you dislike chiropractic so much that you can never believe it? You're probably going to hurt your will. So, which we will call bias. There are also other types of strikes. A person can be disqualified from serving. If you still, and I won't go into a lot of detail, but if you have a criminal record, certain types of criminal records, you can be disqualified. If you live out of county, you're absolutely disqualified. You still have an outstanding, you live in Hoffman, you can have. That's a disqualification. You can also claim exemption. One other disqualification. If you, and this comes up almost every time, if you cannot meet your line, that is a disqualification. One of the things that comes up in almost every trial is people who try to get out of jury service because English cannot. That is not the standard. The standard is clearly utilized. So I've had people literally who have degrees from an American university where they study English and they claim they're not because they it's a very low standard, but you do have to do it. So that is, you can also claim what's called an exemption. An exemption, the most common one is, the two most common are if you have children, maybe 12, if you're going to care for the child, or if you're full time. Those are the two most common. Those others, so you can claim exemption. All of those are kind of under the rubric of challenges. So why do we talk about why is there an extension on it? So you have to be able to have enough jurors to fill out after you've done your strikes for cause to fill out a strike. Okay. What is a strike? Strike zone, the way to calculate your strike zone in a particular trial is you take the number of jurors you need, the number of primary challenges per side, and that is your strike. It's how many jurors you need. So in district court case is our first test here of math. What is a strike? In a district court, this is a little bit of we make it flow. Who makes it flow? Why do you think it's that's a point? Okay, we think why do you think it's flow? With the number of jurors plus the number of countries that on the side. Why do you think it's I use politics, but they out doing this. 12 plus 6 plus 6. We got 12 plus 6 parentheses per side. 12 plus 6 plus 6 will lose 44. So that's your basic price of the case.
Do you not need another for an alternate?
You could, we don't. That's we're not there yet. But that's you're jumping ahead of the sort. So good job. So you have to have after you judge your challenges for cause, you have to have enough jurors to fill out your trial. If you don't, you are not able to afford it. So why are strike zones so important? One, any juror when we exercising your primary challenges, the only jurors that really matter are the jurors within the strike. So, for example, if you are, let's say you have no challenges for cause, the first 24 jurors are the only jurors who want to exercise the Frankfurt challenges with. These are the only jurors that can be reached in jury selection. It's the first 12 jurors that are not struck with challenges for cause or permanent challenges in the appeal. Is this not making sense? So far? So let's look at this chart. So it's getting better. You can see the chart goes from 1 to 12, 13 to 26, and 27 to 40. The jurors are all known. The first 12 that have not been struck become the juror. So, who is more likely to be on a jury? Juror number 1 or juror number 4? Why? It would be the original size. The first 24 that are on the jury are much more likely to be taking people. So the basic strike zone is 24. Does everyone understand this concept? The first 24. Every time I do this, I look back at the things that that's up. Okay. But it happens every time I do this speech. I think it's the that's a so you have 12 plus 6 plus 6. So the strike zone can change. Why do you think the strike zone can change in terms of the level of simplicity? Exactly. If you strike jurors for cause within the strike zone, will change the strike zone because it's the first 24 jurors. So you did a great job there. With juror number 1 is from strike for cause. What is now the strike? You want to know this and this. I mean a little bit. Good. Love that. Listening to you, I love that. I just saved my whole day. So 2 through 25. Does everyone get that? So juror number 1 is struck. It's the first 24 that have not been struck or from your strike zone. So number 1 doesn't count anymore. So it would be 2 through 25. It would be 3 through 25. All right, so let's I don't want to put in too much, but let's say jurors 2 and 40 have been struck. What is your strike zone? What is that? This just 2 and 40. Wait for 26 minutes, but the back not. So just jurors 2 and 40 have been struck. Where does it start? Just number 2. It's still number 1 on the board. It just say 25, you know, but it's 25 is the strikes because what about your number 4? Not in the zone. He's not in the zone, exactly. He's not in the zone. He has to be within that first 24. So he's outside of the first 24. Because everyone gets this. It always takes a little while. All right. Anna said she got it. All right. 2, 25, and 40 have been struck. What is the strike? I almost always trick people on that. You got it right. Why do you say 6? Wow, that's really good. I'd say 90% of the time people do not get that the first time. You guys get what you just said. So you figured out my trick, which was 25 usually you would think is outside of the strike zone, but because it moved to 25, it moved to 26. That makes sense for everyone? Yes, well, okay. So let's ask Jeff. So you 3, 13, and 23 struck. What is your currency? 3, 13, and 20. Right. So how do you do it? Yes, you had a question. That is exactly right. You're right on the clock. You guys have been great so far.
So this might be But when we first, one for cause, we said, it's two.
Oh, he said, yeah, so that is that, which really
Oh,
was
it's-
25.
Okay.
But he's right, 225, that's a good track in. So what happens, what do you think happens if you exercise a strike when you're peremptory challenge? Let's say you struck number 2. And you know, you turn in your peremptory challenges, and with your peremptory challenges, you struck 1, 3, 4, 5, 6, and 35. What did you do with strike 35? Well, you wasted it. Why? You're never going to get there. And what do you think the judge is thinking? Amateur, rookie, idiot. You just showed you don't know what you're doing. We want alternates to not know what we're doing. Okay. So to never do that. Other thing is always exercise your 6 times. Don't care if you're not sure if you want to try. You should either you've got a really good bad job in Fort Dyer, or you don't know what you're doing. You always exercise. Anyway, so if everyone kind of get the concept now of how to do stuff. Now we're going to go to the issue you brought it up about. Right, so first off, what is an alternate juror? Alternate juror is a juror, not in every case, that is there to fill in case one of the original 12 jurors is unable to. So you have 1 alternate juror, you have 2 alternate jurors, you have a 6 alternate jurors. We have had a case from 2. But you can have a percent. So if you have alternate jurors, that will change your strikes. So Matt, because you brought this up, let me explain how this works. So you have 1 or 2 alternate jurors. Each side will get an additional point. We have 3 or 4 alternate jurors, each side will get an additional 2 strikes. For every count. I'll just tell you what I'm testing what happens. 5 or 6 alternate jurors, you have 3. Okay. So you have 1 alternate juror. What is your basic function? Awesome.
It's okay.
So, awesome.
It's just one.
One. $27. All right, we got there. 27. Good job. We got Austin, right? No, man. Austin on the left. Awesome. Okay. All right, Dave. I feel like you're getting this. All right. You have 3 alternate jurors. What did you try? Well, I would figure it out. It would have hard possible. You got 24 plus.
I'm saying please right now.
Plus. I'll get that. All right. So the 4. The 4. The 4 plus. Calculate that one. 24 plus what plus what like before. It is 32. All right, so we got it. Good job. Good job. Is everyone kind of getting this concept? So far, you guys have been great. Wake up. And usually we'll have at least one of the interns who does not, but we're still dealing with the first topic, this is one. So you don't get it? Okay, all right. Well, so what do you not understand?
I think I'm lost at the
Yeah, the alternate is where you lost.
Okay, so what is it that amounts to?
The alternate makes sense. I think for me, it's the. We have to. So maybe add
So
one.
so if you have one or two alternate jurors, you get one additional confirmed side.
So if you get two alternate jurors.
You have one extra side. Does that help?
Yeah.
Oh, anyway, it's okay if you're not getting them. This is very common.
Okay, so you have two alternate, you get two, one per side.
Yes.
Alright, so you get three, you get two per side.
Yes.
You have one.
One or two. And by far, at least the my court, the most commonly attached. Very little, two, and then almost. So. Four is 2%. No, then if you have five, I think it would be 5 or 6, you get 40%. I have never done. I've never done 3, so, but I have heard cases that were done this way.
What's the difficulties of the discussion?
It's up to my discretion. Now let's talk about it. That's a good question. We always get to good questions. Good job. So, someone's going to the next step. Why do I want it? What do you think? Why do I want it? So what kind of faces do I want? What's the number one reason I call it? That's so loud. That's one thing. And what case is going to go yes. The longer the case goes on, the more likely to lose. Right? If you're only there for a day, what's the likelihood somebody gets under? If it's going on for a week or 2 weeks, my kind of rule of thumb is just my rule. But every week goes, I'll have a note in the second week, the third week, that's kind of like that. So why is it important? So one of the things the Texas Court has told me as a trial judge is that we prefer 12-person juries. And if I have a juror, let's say I have a juror that's sick, I have to show the court of the field, I'm striking that quote. I'm saying, I'm going to let you go. Let's say maybe we're on the jury, you strike, you get a ton. And you think I can get the weapon. What if she has broken up? Yeah, and she walked. Probably I cannot let her go because I have to show that she is unavailable. Let's say she dies. I can probably let her go. But the standard is extremely high. But if I have an alternate, it's much easier for me to say, Megan, I'm sorry you broke the right. We're going to promote a better alternate. And it's much as I would have. So it's to preserve my ability to have a person. Okay, we're going to go to one more extremely important task that really will go into the text. Why does this all matter? Why do we even care about it? Why does this even happen? What did I say at the very beginning? How many jurors do I have to have left over after the strikes was paused in order to get over? 24, exactly. Why 24? That's my strikes. You have to have a strikes. So let's talk about a key issue. I have 40 jurors here. Why did I bring you 40 jurors instead of just 44? And we push it. That get rid of this. We push it. So what happens if I have a 40-person jury and I strike 17 jurors? Set it right. It's a mistrial. If I don't have enough jurors to fill out my panel, I have done what's called busting the panel. You want to know what that means? I have busted the panel. You don't have any. Huh. Let me make sure I'm not missing something. So have you ever had a busted panel, Sheriff?
Oh.
I've had very close calls. I've busted panels too. Let me find what he's here. Mr. Crouch, what are you here for? I don't think we have any hearings until 2.
I was here. There was a Zoom hearing on a motion for summary judgment in the Lythen case, but the parties have just reached a settlement. I just wanted to make sure that that news reached you.
Thank you for sharing. The what case? Like, oh, you're at
Nick Lythen versus GFO Home LLC.
okay. So just let them know I have to have a notice of withdrawal of the summary judgment, or I'm going to just deny it. But
Okay.
I need to have a notice. You can't just pass it anymore. We have to have a notice of withdrawal.
Okay, I'll let them know.
Okay. And then if they want to show up at 2:30, I can also just deny it. So that works too. But it's up to y'all how you want to handle it.
Okay. Thanks so much.
Thanks. Bye-bye.
Bye-bye.
Okay. Nobody was right in on that. Okay, so let's talk about busting the panel. So that is an issue that as a trial judge, I'm always thinking. If I strike more than 16 jurors and I took the 40-person panel, then I have busted a panel. So we may think that's not that big a deal. That means I have to summon the 40 citizens and all hearings and court. I have to go through this process again. I have 12 more cases. I'm hesitant to bust it. I have done it, but I don't mind. And so let's calculate, how do you figure out how many jurors you can strike? So we talked about the 40, 41, 24. Let's say we have a 55 case. How many can we strike without busting? This is now. Wow, you're good at this. You just figured out on your head? That's well, you obviously you do it the best. You heard my lecture, but that's really good. Pretty good. So let's say you have, let's make this a little bit tricky. Our ultimate juror expert over here, Austin. So you have one. You're going to have one alternate juror. How many can you strike without busting? 40%. Show us you.
Well, 27 is the spreadsheet.
How do you do that?
12 juror baseline plus the 6 normal rankings per side, plus 1 alternate, plus 1 additional members ranking side.
You got it. You got it. 27.
40 minus 27.
That's the most you can strike. What you strike? Well, so I will tell you, so I'm just giving you a little bit of behind the scenes here. Yes, that is true. If I want to have an alternate, but what can I do as a trial judge since it's discretionary? If I'm in that situation, I can just play. But that gives you an idea. You want an alternate. Does everyone understand the math and how? Does anyone have any question? Are you getting this? No, you're not. You're not.
I would get it and see it in close.
Okay. Is everyone getting this? No, yes, no. This is important stuff. No. I can ask them to agree to, but I cannot just tell you. So both sides agree with the and I've done that before, in order to save a panel, I'm asking, look, this is our option too. One of the, big thing I forgot to mention, when you're talking about challenge, one of the types of cause is very, very common. And this is why, as an experienced child, that I use a little bit of discretion. One of the things that was totally discretionary with the attorney, is if a juror has a hardship. You don't hear this idea of hardship. What is a hardship? Let's say you have somebody, let's say she's going to Florida to get a spring break with her friends, and she has non-refundable tickets and she wants to go to school. Is that a hardship? Is that a hardship? Who thinks that's a hardship? Who thinks that's not a hardship? He's not sure. It's really up to the attorneys. Like I will say I give them advice, but I have never actually studied with a hardship unless your attorney's for it. But a lot of times, the way we're human beings, we want to let the go anyway. It's really about the business. We might let her do that if we have enough jurors. We don't have enough jurors, I may not start. Let's say that Jeff has tickets to, let's say Jeff has a doctor's appointment on Wednesday and also on Tuesday, which is what he Thursday. Was that? That's what the doctor is. All right, so you're the attorney. Let's switch it up on the side. So team 1 and 2, you're over here. Team 3 and 4 are over here. Okay. 1 and 2 over here. Below. Keep saying. Okay. 1 and 2 over here, 3, 4. All right. So we're kind of test you. Okay, 1 and 2 over here, 3, 4. You're going to consult amongst yourself. Your team, 1 and 2, 3, and 4. Let's go through some hypotheticals. We'll start off with Maggie's spring break. The non-refundable tickets. You guys confer among yourself, you confer between yourself. Is that a hardship? Confer amongst yourself. That's what's it's wasting money. I would right. All right, team 1, what's your decision? Agreed, son. Yes. All right, team 2. You're in it is a hardship. It is a hardship. So you guys agree and strike. Okay. Let's say we'll do Maggie, pick on Maggie every time. So Maggie, you're not one of the attorneys. Maggie has a doctor's appointment on Wednesday, and she doesn't want to tell you what it is. But she's gonna be at the appointments and paid, and she won't be there. 1:30. Is that all? Yes, that's Team captain, what is your team captain, your team captain? What is your decision? No, you don't agree. Don't agree or don't agree. Okay. Maggie says, okay, I have a doctor's appointment. It's for a surgical appointment I have next week. And if I don't get it, I'm not going to be having surgery. All right. Team one, team one. We're starting with team two this time. I think team two. No, that's all you know. Team two. Yes. All right, you got out of it this side. All right, you have, it's Tuesday. You think the trial will finish by Wednesday, but it might go into Thursday, and she has surgery, so. You let her go now. Surgery scheduled for Thursday, or not Thursday. Yeah. I'm gonna let Ava be the new captain and Hannah be the captain. Hannah, all right, guys. Ava. No, you don't know. You agree? Agree? You agree? Hannah says, well, no, agree or not?
Yeah.
Okay, so let's get into something a little, this, I'll give you all examples of that happened before. Let's say that you have somebody who, you guys are young, so you can figure out some simple stuff with all this stuff. It's gonna be a 2-week trial, and my son is graduating. Your honors, my son is graduating this Friday up in Cornell. I have to fly up to see them. I'm not gonna be able to get a trial on Friday. I'm gonna ask my son for a. Do you agree? All right, Sally. No, do you agree? You agree? Yes. Yeah, what do you feel? I don't know. At some point, I've got to agree with you all. All right, guys, that kind of fun. You guys, all right, this.
People say anything, what versus that, I have soup competition.
That's okay. Now we're gonna do, actually, now we're gonna go on, it could be plastic surgery, is that what you said? All right, I'm gonna give you guys now a quick tour, the gentleman in today.
It's not going back to, but we can do that.
Okay, so I could go by, because he gets really sensitive. Okay. So I'm gonna give you a quick tour here, so bring your stuff with you, I want to give you a quick tour of everything, kind of to understand what's going on here, so we're gonna do a little bit, you guys, how much you guys bring your notebooks. Okay.
Just like if you're in like you're in Mexico, probably the more insert area. Right?
What can I do for you?
I think I must.
Oh, okay.
Um,
How can I be rich?
I need to know what it is. It says on 64th. Is it Philippine?
What's it? It's not a radio. What is that? Let's cut that off, please.
I mean, how much?
I'll take that outside.
Oh, okay. I think I'll put on.
Let's see. What are you trying to do?
Prominence.
Well, probably the clerk, you know, the last one. Tell that to them, and if that doesn't work, come back. I can tell.
Well, thank you so much.
Have a good day.
Thank you.
You guys mind throwing those bags away that they're empty? All right, guys. All right, those on the Meehan versus Texas Health Presbyterian case, you guys all here?
I don't see Alan Campbell.
I don't either. He says he's in the waiting room.
Let me see. I don't have anyone in the waiting room right now. Okay, I still don't see him. Do y'all want to wait for him and I can go to my next hearing, or do you want to just go forward?
Okay.
He says he's in, but I don't see him.
Maybe. He's not here. It's up to you guys. Do you want to go forward or do you want to wait for him? Because I have another hearing I can go to.
You can go to the next hearing.
All right, Salters versus CC Young, Senior Living, are both sides here for that? That case was non-suited. This Mr. Campbell. All right, Mr. Campbell, are you there?
I am, Your Honor. I'm sorry. I was here and then I was not, but I'm back.
Good. What did you guys figure out?
I think September 29th is the only date that all defendants could come up with Bill Dipple for mediation.
Is that right?
Yes, Your Honor.
Martini, what do you think?
That works for the plaintiff as well, Your Honor.
Okay. All right. Let me give you some dates for the trial setting. And the way this will work, I'll put you guys into breakout rooms. I'm going to give you 3 dates, and you guys can pick one of them that you want to go forward with. If you think you need extra time, you could come back at 4 if you'd rather not just do this while you're in a breakout room. But I'm going to give you 3 dates. You each get to veto one. So one of them is October 27th. How long is this case going to take to try?
I would say a minimum a week.
Okay.
My guess is it will bleed over into the second week, Your Honor.
I would agree with that.
All right. The second date would be November 17th. And the third date would be December 1st. So I'll put you guys into breakout rooms and you guys can just tell me plaintiff gets the veto one, defendants get to veto one, and then how much time do you need to figure out which one you want to veto?
Your Honor, I don't know, maybe my calendar's off, but I thought we had round tabled some dates, I think pursuant to your request, and came up with December the 7th. Is that not a?
Okay. If you guys all agree.
We cleared that with our client, I know.
Ms. Martini, does that work for you?
Let me just check real quick. I don't see that being an issue. But we can certainly clarify that in that roundtable.
It was my understanding we'd also cleared November 2nd. I don't know if that's accurate or not. I was told that.
But when we say we've cleared these dates, I don't know what we're talking about. Like, you guys have had this conversation, because I don't recall these conversations.
I sent an email around. I have not cleared November 2nd. The only date I've cleared for trial with my client is December 7th.
Ms. Martini, it'd be the 8th, not the 7th, but
Oh, 8th. Okay.
December 8th for the trial. Let me check with my experts. That shouldn't take very long.
Okay. Let's do this. I'll go to the next hearing after. Well, I don't know if there's any other hearings. Is anyone here not on this case?
I am, Your Honor. I'm early for your 2:30. I apologize.
Oh, it's okay.
Hey, Your Honor, this is William Sanders. I'm here for the Claude Ford hearing versus City of Dallas.
Or that's at 2 o'clock, right?
Yes.
Oh, it is 2 o'clock. Where's the other side?
They are not here, and I'm not sure that they are going to be appearing. Opposing counsel has indicated that she's been extremely busy.
Your Honor, sorry. Your Honor, this is Stephanie. I'm here, sitting on behalf of Ms. Pavelic. She had, a previously scheduled mediation, so I'm here appearing on behalf of plaintiff.
All right. So you guys are set for trial tomorrow. How long is it going to take?
I believe it'll take 2 days, Your Honor.
Ms. Ray, is that about right?
Yes.
I've already ruled on this, but you guys are welcome to chat.
Your Honor, I'll start here. We filed our unopposed motion for administrative reset on the basis that the city's plea to the jurisdiction that was filed on June 22nd has yet to be heard and ruled upon. And so the question of whether the court has subject matter jurisdiction remains unresolved at this time.
You can't wait until, I mean, maybe the Court of Appeals will tell you can, but you can't wait until the last minute to file your plea just to get out of a trial setting. Maybe the Court of Appeals will differ with me, but I'm not going to continue this case because you waited until what, a week before trial, 2 weeks before trial to file your plea. You got to get that filed farther in advance. So
Your
we'll
Honor,
see you tomorrow.
I understand. In addition to the Court of Appeals saying it can be filed at any time, the Supreme Court has also indicated that it can be subject matter jurisdiction can be raised at any time. And also a recent Texas Supreme Court case indicated that pleas to the jurisdiction must be ruled on before we proceed to a trial on the merits. And so we're asking just for a short continuance so that
Mr. Sanders, you can have the Court of Appeals tell me that, and maybe that's the case, but I'm just not. If you had filed this in a timely manner, I would have been glad to hear it. But you can't wait till the last minute just to get out of it. Maybe you can. Maybe I'm wrong. Maybe the Court of Appeals will say, "Look, you have to stay this because you can file this at any time." But I don't think that's what the case law says. You can raise jurisdiction on appeal. That doesn't mean I have to cancel my trial setting. And so maybe you're right. This will be something that could be reversed on appeal, but I'm going to let the Court of Appeals make that decision. We'll go to trial tomorrow.
Your Honor, respectfully, if I may, the Supreme Court case that I'm referencing is a relatively.
Mr. Sanders. Mr. Sanders, I've made my ruling. I will see you tomorrow. Okay.
Okay. Can I ask you this? Are you refusing to rule on the city's plea to the jurisdiction?
It has not been set for hearing. You're welcome to get it set, but you never set it for hearing.
We're asking for a continuance so that a ruling can be made.
The continuance is denied. We'll see you tomorrow, Mr. Sanders. All right. We'll see you guys tomorrow. Okay, sorry about that, guys. What did you, Ms. Martini? Were you ready yet or no?
As far as determining on the trial date, Your Honor?
Yeah, I'm sorry.
Yeah, I'm looking at the November 17th or December 8th. I'm trying to reach out to my people to make sure that one of those will work.
No worries.
And as soon as I get a response from my experts, I will let you know, but I'm hopeful that'll happen here shortly.
All right, no worries. Do you guys just want to reconvene at like 3:30 or something, or do you want to just wait for her?
We can do that, but we have a couple of other things on the docket. I suppose we could go ahead and wrap up now if everybody wants to, while we have your attention. I think we have the motion to strike. The continuance, obviously, we need to hold off on. And then we saw that issue on the summary judgment on the evidence.
All right. Well, let's go ahead and go forward.
Okay.
Hey, did you send this? Wait, did you send this case?
Yes, sir, I did. I sent a letter with 3 cases attached, and I did mark them urgent for your attention. So if you've not received them and you want to push this back to 3:30, that's fine.
Rhonda, can you forward me those cases? Who did it come from?
It came from myself, Tanya Martini.
Looking for him now, Judge. You said Tanya Martini?
Martini, like the drink.
I don't see anything on here.
It was submitted at about 1:50. And if you have an email, I'd be happy to email it, but I did serve it on all council record as well.
Let me give you my email real quick.
And it doesn't look that it's been admitted, accepted yet. I don't know if that makes a difference.
There's my email right there. If you could just forward it to me real quick.
Okay. Is that in the chat? Your email, is it Rhonda.Pinson?
Yes, at dallascounty.org.
Ma'am.
Any luck, Rhonda?
No, I'm still waiting.
Have it en route.
I'll refresh just to make sure. Nothing yet.
Promise I sent it.
Sometimes it takes a while, because of all the firewalls.
And I copied all council, so if any of y'all get it, let me know.
Well, I got the e-serve.
Yeah, and I just sent the email that I sent to Rhonda. I copied out all the council just to be on the up and up.
Oh, there we go. Okay, I'm forwarding it to you now, Judge.
Yeah. Thank you.
Okay, it should be coming soon.
Got to me a lot quicker. Let's see. What page am I looking for in the Guerrera case? Oh, I see it.
There is,
I see it. I see it. All right, you guys can proceed. Right on.
Your Honor, I just, while we're on the subject of Ms. Martini's letter brief to you, I think it was e-served at 1:53, so I haven't had a chance to review it in depth, but it appears she's relying on Wilson versus Buford. The attachment in that case was sworn deposition testimony. That's much different than these hearsay expert reports. There's no dispute. If you have sworn deposition testimony, that's competent summary judgment evidence. But expert reports or hearsay, they're not admissible for any purpose. And I think she told you this morning that me producing them authenticates them. That may be true, but that doesn't make them admissible. We'd like an opportunity to respond to her letter brief, Your Honor.
No, that's fair. Let me see. So you say here, and maybe I just didn't find this brief, it says the courts established that while simply attaching a document to a pleading does not make the document admissible as evidence or dispense with foundational requirements for your own use, it acts as a judicial or adoptive admission of its authenticity if relied upon by the opposing party. And maybe I just didn't see it. I've been looking at the In re Guerrera case. I just maybe didn't see that part, or maybe I just couldn't find it.
I think maybe the case that's more on point generally is going to be the 2025 Supreme Court case from what is it, State of Texas versus 3000, where it talks about you can use filed summary judgment evidence in a response if you sufficiently pinpoint the evidence that you're citing in the response found in the motion. And that's what we did here, or what I did here. But even assuming, say, the court determines that that evidence isn't reliable that was attached to the defendant's motion, I would still be granted the opportunity to rectify that under the rules. I think it's a mandatory allowance. And beyond that, there's still, we have attached to that response the deposition testimony of Dr. Patel that addresses, I believe it's going to be the second prong of the gross negligence issue, objective and subjective data or reliance on to establish the gross negligence. We've got Dr. Patel's deposition testimony and Nurse John's. And as far as Nurse John's not being a corporate rep or not having sufficient status, that's irrelevant because that wasn't raised in the initial motion. And anything that's not raised in the motion, and especially if it's raised in the reply, can't be considered.
Your Honor, just briefly, a no evidence motion for summary judgment raises all elements of the cause of action, and it's no secret that in order to impose gross negligence on a corporation, you have to identify a vice principal. And if there's any doubt, we can just look at the pattern jury charge. You have to name an individual, and she's clearly not qualified. She's just a nurse. She's just an employee, and respondeat superior doesn't get you there.
Okay, so this, guys, this is what I'm going to do on this issue. I'm moving this trial to December 8th. I'm going to deny this without prejudice for you to refile this, Mr. Campbell. That's kind of the only way to do this right now. Ms. Martini, I'm going to give you an opportunity to, I don't really like doing it that way. No, I'm not going to deny it without prejudice. I'm going to give you, Ms. Martini, an opportunity to amend the affidavit. I'm going to reset this for hearing on July 27th. Rhonda, are you there?
Yes,
Rhonda,
Judge.
so we're going to reset this summary judgment that was heard this morning to July 27th. And in big, bold, this is not allowed to be canceled by judge without court appearance, court approval.
Your Honor, I have a deposition in Oklahoma that day. Is it possible we could do the 28th perhaps, or?
I could do it the Friday before.
Which day is that, Your Honor?
The 24th.
That would be fine, Your Honor. I think we already have something on the court's docket that day.
That might be good then.
And my own issue, and I'll just, the council is already aware of this. I'm set for trial in Judge Ballin's court on July 21st. We're number 1 on the docket. So we are mediating that case on the 14th. So should that case resolve, then I won't have any issue. But if we are going to trial, then I will be in trial.
I mean, Mr. Campbell, this would be over Zoom. Could you do it on the 27th?
My deposition's at 10 o'clock in Tulsa, Judge.
I mean, could you do it at 9 over Zoom?
Sure. But I understood from my previous conversations with Ms. Martini that her trial was going to bleed over into that week.
I could ask the court, Judge Ballin, if she'll give me leave to attend this hearing, Your Honor. And I've got a co-counsel that is trying the case with me, Heather Long. So I should be able to step aside for a few moments to address this with this court.
All right, let's do the 27th at 9 o'clock. We set it over Zoom.
If I'm at the courthouse, is it okay if I'm there in person versus being there by Zoom?
I mean, I may not be here, so you can, I mean,
okay,
I'm not sure.
I do a Zoom in the courthouse.
Yeah, it works okay. All right, guys, we need to chat about today. So we reset the December, Rhonda, we set this case for trial on December 8th, and we set this for summary judgment. Ms. Martini, I'm going to give you leave to provide an additional affidavit on this issue. And then, was there another thing that I was supposed to decide here?
Yes, Your Honor. The motion to strike Joshua Simon.
Okay.
I can be as brief as I possibly can, Judge.
Okay, go ahead.
This is a Chapter 74 case. It's undisputed. It's a healthcare liability claim. It's also undisputed that Texas Health Dallas is a healthcare provider. We only need to look to 74.402, which tells us what you need to be in order to be an expert in one of these cases. You got to practice healthcare. You have to have knowledge of the accepted standard of care. You have to be qualified by education, training, or experience to opine on that standard of care. Mr. Simon is a software developer. He does not practice healthcare. Ms. Martini says in her response that she's not offering him to comment on the standard of care, but that's nothing more than what the Supreme Court has described as claim splitting or recasting. She's trying to avoid the somewhat punitive provision in Chapter 74 that prescribes who can testify. When we look at the pattern jury charge, there's not going to be a blank for, do you find the medical records to be in order? You need a doctor to say that there's something wrong with the medical records. And this Mr. Simon is simply not qualified to be an expert in a 74 case. That's it.
Ms. Martini?
Well, that's incorrect because in hospital cases especially, parties always or frequently will retain experts who do audit trails on the medical records. And this particular person, Joshua Simon, is an expert on the audit trails that are and medical records that are created by this particular defendant, Texas Health Presby. He's not there to talk about the standards of care of the medical care provided. He's going to testify about the documents that were produced, the lack of documents, or how the documents don't establish the timeline and events that the defense is trying to present at trial. And that he's not a Chapter 74 expert. He's an expert. His analysis would fall under a Robinson-Daubert analysis rather than a Chapter 74 because we're not presenting him as a medical expert. That's detailed in my response. And moreover, any objection to his qualifications is untimely because it should have been filed 21 days after I designate him on April 1st. And this motion wasn't filed until June 30th, so it's untimely.
As to the timeliness, Your Honor, as the court well knows, it's a bifurcated test. We have 21 days after his deposition. His deposition hadn't even been taken yet. So it's timely. And again, he just doesn't fit. There's no place for him. Sure, we produce audit trails and doctors comment on the integrity of the record because they're the ones who know. This man is a software engineer. He may advise healthcare clients. He may tell them what he thinks should be in a medical record, but he's not a medical person. And he's not qualified according to Chapter 74 to testify about anything.
Is there any case law on this topic about, I've never had anyone with this type of background testify in a med mal case. So is there any case law that covers this type of situation?
I believe that this is an emerging theory among the plaintiff's bar, Your Honor, so no. But there's just no, I know that Chapter 74 is punitive. It's tort reform, but there's just no place for him. If you look at the jury charge, there's no place for, do you find that the hospital's records were in order? Do you find that, it's just, one of her experts might rely on him, but that's not the way she has him designated. She has him primarily testifying without anybody relying on his work product. And that's just not proper here.
And he's to substantiate the gross negligence claim, Your Honor, because part of the gross negligence claim is the departure, the deviation from the hospital's own its own policies and procedures on medical records, record keeping, and altering of those records. And that's exactly what Mr. Simon is testifying about.
What I'm going to do with this particular expert is I'm going to hold off on making a decision and wait till we get closer to trial. Maybe you said, Mr. Campbell, you're seeing this a lot. Maybe there'll be some appellate court decisions that address this issue. But I'm going to hold off on ruling on this until closer to trial since we gave you guys a continuance. All right.
Thank you, Your Honor.
Your Honor.
Thank you.
Your Honor. David, Chris, I just wanted to make sure we had reached agreement with the court on the mediation date as September 29 with Bill Dipple. I think that's what we'd agreed to.
That's fine, and that's why I moved the trial setting. Rhonda, go ahead and do a new mediation order for Mr. Dipple for September 29th.
And would you like the parties to submit a new scheduling order?
If you'd like to.
Your Honor, in light of the court's ruling, we'll proceed with the deposition of Mr. Simon then.
Okay.
Thank you.
Sounds good. And if you find any more case law on this, if this is kind of a new thing, then please let me know.
Absolutely.
Thank you, Your Honor.
All right, guys, you have a great rest of your day, okay? Get me those orders as soon as you can.
Thank you, Your Honor.
Thank you. Anyone here on Frontline Invesco versus Sharma?
Yes, Your Honor. Grace Burgard and John Easter here for Frontline, the plaintiff.
Yes, Your Honor. Brian Hale and I believe Drew Robertson is also on the line on behalf of the Dr. Sharma. Thank you.
And we dealt with the compel this morning. I think we finished with all that, right?
Yes,
Well,
Judge. We
Go ahead,
did
Drew.
just have one brief clarification for you, Your Honor, before we get into this afternoon's motions. So the defendants submitted our proposed order, which was agreed as to form by the plaintiff. The plaintiffs have, I guess, a slightly different view of what you ordered, and I'll let Ms. Bergard address that. But I just wanted to say for clarification, there were a number of things in their motion, additional items that were not raised at this morning's hearing that counsel did not go into, did not argue. And so when you ordered all of those objections are overruled and we should be compelled to produce by Friday, we took that to mean the items that were actually raised at the hearing this morning. And when we got the draft order from plaintiff's counsel, it included everything from their motion, including all of the stuff that was not raised at the hearing. And we disputed that that's actually what you ruled on this morning.
And Your Honor, I think there's a misunderstanding as to what I addressed this morning. There's a question as to defendant thinks that certain requests are not relevant to the fraudulent transfer claim. It's plaintiff's contention that they are relevant. So there's a disagreement there as to what is relevant, what's not, what was addressed, what was not. It was my understanding that I addressed all of those requests for production because they had to do with the fraudulent transfer claim. But I understand that that's not their understanding. So that I think there's just been a miscommunication there. I heard that all objections were overruled, and when defendant mentioned everything's been sufficiently briefed in this case and everything's, before the court, that was our understanding. We can go into those. We think that we're still entitled to production in those for those requests. Those requests being communications, showing when defendant got notice or any demands for payment. So show the intent of the defendant when there were transfers. Did he know that there was money owed at that time? What was the scheme going on while defendant was paying my client? What was being transferred between the entities at that time? What was the compliance there with the agreement and who was doing it? We thought that was all sufficiently addressed this morning and that those documents should be produced in this case.
Okay, there's a lot there. I guess this is what I would suggest we do. You guys confer on each individual request if there's a difference of opinion about that. I can put you guys into a breakout room if you want. If you can reach agreement, great. If you can't, great. My intention was that anything directly related to the fraudulent transfer claim would be produced. I don't know how transfers between two different entities, if they weren't, I assume that means, like let's say that defendant company A transfers it to defendant B or to company B. Any discovery about that would be admissible or would be permissible. And then, but if it's about whether or not company B's transfer to company C, that would not be related because that's not part of the transfer that occurred. Does that make sense?
Yes, Your Honor. And of course, part of the problem was that additional items that they included in the proposed order were things that had to do with like the fraudulent inducement claim, that the claims that the court has already dismissed on summary judgment. And our position is any claim that's been tossed out by the court is no longer within the scope of discovery.
And Your Honor, we don't think that any of our requests have to do with the fraudulent inducement claim, but we'll talk about that in the breakout room and come back.
Who wants to go into the breakout room?
If me and John Easter could go.
I believe there are also the two motions that are set for hearing this afternoon, Your Honor, though, that Mr. Hale was going to address.
Yes, Your Honor.
Do you want to wait? How many attorneys are here with the other side? Ms. Bergard, are you here by yourself?
I'm here with John Easter from my
Can
firm.
Mr. Easter argue continuance and you confer on the compel or no?
He is mostly here just for support. He hasn't really been involved in this case, so I don't think he's familiar with the scheduling.
Yeah, I do apologize, Your Honor. Mr. Fronda is a partner at our firm is on this case who's traveling today. He asked that I kind of step in just to observe and monitor. I have a base knowledge of this, but I do fear that Grace may be the best one to argue.
Let's just hear the continuance then. Go ahead.
Okay. Your Honor, plaintiff has filed a motion for continuance in this case. The good cause for Our trial date is August 11th. However, defendant didn't file their answer in this case until October 15th. And that's because originally there was a default judgment and then a motion for a new trial, and then the case was reinstated. So discovery has only really been going on since November. That's when plaintiff first served their discovery requests, then got responses after a brief Rule 11 agreement extending defendant's discovery deadline because of the holiday. Plaintiff got discovery responses in January. In February, when plaintiff first sent their first letter saying, hey, there's issues with the production in this case, the original counsel withdrew. And that's when current counsel joined the case, and they asked for time to get acquainted with the case, get documents, talk to their client, and then requests for supplementing discovery were delayed and ignored. And then finally, we came to an agreement once defendants served their own request for discovery, came to an agreement we're all going to produce everything in May, in like late-ish May. And when that happened, there were still discovery issues. That's why we had the motions to compel this morning. And when plaintiff filed their motion to compel, they also filed the motion for trial continuance because we have mediation this Friday. We need the documents to see everything that's going on with the fraudulent transfer so we can follow the money here. And defendant is opposed to the continuance, but they did file a motion for leave so that they could have their motion for summary judgment heard. They filed a motion for summary judgment in this case on the remaining claim, the fraudulent transfer claim, on Friday, this past Friday, the 2nd. I'm sorry, Thursday, with the holiday, Thursday the 2nd. Didn't have any evidence attached to it. It does reference documents that haven't been produced yet. It does reference an affidavit we haven't seen yet, and it came with a cover letter saying, Your Honor, we will file the full motion within 2 business days after the court grants leave for the motion for summary judgment to be heard. Under the new summary judgment rules under 166, if they filed their motion for summary judgment today, if the court granted them leave for it to be heard today, they have to wait 35 days before it can be set for hearing, and that would be August 10th, the day before trial. That prejudices plaintiff. We'd have to be both responding.
Let me just say this.
Mhm.
The rule in this court and for 12 of the 13 courts in Dallas County is that summary judgments have to be filed 90 days before trial. So if we're going to stick with this trial setting, you're not getting a summary judgment, Mr. Hale. So if you want to have your summary judgment heard, then we need to move the trial setting. If you don't, then we'll keep the trial setting where it is.
Yeah, I thought about it, anticipating Your Honor may have that position. I'd rather have the trial setting, and I'll just turn it into a directed verdict motion because I know they don't have anything on this issue. So,
okay.
And I think that may eliminate the need for continuance. But if I need to argue on that, first of all, there's no compliance with Rule 252 when you make an application for continuance.
Mr. Hale,
Yes.
Mr. Hale, no, I'm denying the continuance, and I'm also
Okay.
going to also deny, I guess, the summary judgment as well.
Okay.
Okay.
So I guess I'm not going to probably join the break room because I don't think I'm necessary, but I guess Drew and Grace and whoever else can jump into the break room, and I'll be communicating with Drew if I need to jump back in on this hearing this afternoon as well. Thank you, Your Honor, for your time.
All we have left is the continuance, right? Or the compel.
The compel
Right.
issues, yes.
Yes, Your Honor. The additional items, yes, Your Honor.
All right, so who am I putting into this breakout room?
You could put me and John Easter in there, and then Drew, if there's anyone else from your side you want in there.
If Morgan Jones is still on, you can add her as well, Your Honor.
I'm on.
Just myself.
All right.
Okay.
So we don't need Brian Heddish, Andrew Patchen, or Zach Teague.
They're not with us, Your Honor.
Not
Okay. I've opened the breakout room. Just come back as soon as you can.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Hey guys, give me 1 second. Okay, guys. Well, a lot of people are going. Okay, good. Is anyone here on the Crawford v. Maruva case?
Yes, Your Honor. Zach Teague on behalf of defendant Maruva.
Andrew Patchen here on behalf of plaintiff.
Brian Heddish on behalf of defendant American Family Connect Property and Casualty.
All right, you guys can proceed.
Your Honor, one, thank you for your time. This incident arises out of a motor vehicle incident that took place on Arapahoe Road in Preston on March 15th, 2024. I'm not sure if I have the capability to share my screen on Zoom. However,
yeah, you can, but give me 1 second, okay?
Okay.
Oh, we're on YouTube still. Oops. Okay.
It's
Go
also
ahead.
attached to our motion, whichever is easier for you. Can you see my screen, Your Honor?
Yeah.
So at that time, my client, Unit 2, Mr. Maruva, was stopped attempting to take a left-hand turn onto Preston Road. Miss Crawford, plaintiff in this matter, is Unit 4 down here, attempting to take a left-hand turn onto Arapahoe. My client's light turned green, had a protected green arrow. The undisputed facts state that he then proceeded into the intersection. Suddenly, unexpectedly, and without warning, Mr. Fuentes, the driver of Unit 1, ran the red light at Preston Road, striking my client, and then subsequently coming and going headfirst into Miss Crawford. My client's vehicle never touched Miss Crawford's vehicle, never came into contact with Miss Crawford. Again, never touched her. When Mr. Maruva's signal changed, like I said, he received a solid green arrow, came from a complete stop, and then began to turn his vehicle. Before proceeding, he looked left toward the lane when cross traffic would approach and saw no moving traffic that would interfere with his protected turn. He recalls that most of vehicles stopped in the far right lane on Preston with a red indicator. And as I mentioned, the uninsured motorist, Mr. Fuentes, then ran the red light on Preston and struck my client's vehicle before coming into contact with Miss Crawford. Plaintiff's live petition alleges a laundry list of generic driving failures against my client, such as failure to keep a proper lookout, control speed, brake, take evasive action, distractive or reckless operation, and so on. When deposed, plaintiff candidly admitted she has no personal knowledge of what, if anything, Mr. Maruva did wrong. She was stopped in her own left-hand turn lane on Preston, facing a different direction, and never observed the sequence between Fuentes and my client. The only fact plaintiff can point to is that plaintiff ran a red light and hit Maruva, and that Maruva never saw the pickup before impact. Texas law is clear that negligence is not presumed from the mere fact that a collision occurred, especially when there is indisputable evidence that another party ran the red light, and there is no evidence that anything visible in Mr. Maruva's lane of travel would have altered a reasonable, prudent driver before beginning at a low speed to complete a protected turn. Plaintiff does not dispute that Fuentes ran the red light and was the vehicle that actually struck her head on. Plaintiff's theory is purely speculative that had Mr. Maruva somehow perceived the oncoming truck and stayed put, Fuentes would have traveled through the intersection and never came into contact with plaintiff. That's not evidence. It's conjecture, and it's absolutely hypothetical and about an alternative sequence, unsupported by expert analysis, timing, distance, speed calculations, or any summary judgment evidence. There's no testimony establishing that a reasonable, prudent driver positioned where Maruva was could have perceived Fuentes in time to avoid being struck, or that any such perception. Yes, Your Honor.
Go ahead.
Oh, sorry. My internet's somewhat unstable, so I apologize. That there's no evidence that Maruva could have perceived Fuentes in time to avoid being struck, and that any such perception and reaction would have broken the chain before Fuentes entered the intersection. Plaintiff responded to our motion and actually confirmed that the legal controlling principle that a driver with a green indication must still use ordinary caution and keep a proper lookout. He can't blindly proceed. That's exactly what Mr. Maruva did. He stopped at a red light in obeyance with traffic laws, waited for a protected green arrow, checked for oncoming traffic to his left, saw none, and then began his turn. The fact that he never saw Fuentes before does not impact by itself an established breach, the way that it would be evidence of negligence if there was a record of proof that Fuentes' truck would have been plainly visible to a reasonably prudent driver in my client's position. There's no proof, no testimony about the truck's exact position when the arrow turned green, no time distance analysis, no expert opinions, and no contrary eyewitness testimony. The crash report, as seen in Exhibit D that we looked at just a second ago, doesn't list my client as a contributing factor. My client was not cited for any unlawful acts. He simply proceeded through an intersection with a green arrow. As such, defendant would ask this court to grant our summary judgment as to the negligence brought against my client.
Response?
Yes, Judge, and I just want to make sure that we're clear on we're addressing three motions for summary judgment today. There was the hybrid motion for summary judgment filed by the defendant, and also plaintiff's no evidence motion for summary judgment, as well as a traditional motion for summary judgment. Do you want me to just respond to defendant's hybrid motion at this time, or do you want me to get into the substance of our affirmative motions as well?
Both.
Both. Yeah. Thank you, Judge. Well, first, I'll briefly respond to defendant's oral argument here. One thing I'd like to highlight is there's been a lot of loose citations in defendant's briefing, and that's kind of continued over into the oral arguments that we just had here. Defendant's counsel, I forget the exact phrasing, but insinuated that the plaintiff did not believe that the defendant did anything wrong or was negligent. But with regards to his briefing on that issue, what he cites is plaintiff's exhibit or plaintiff's deposition on page 82, lines 14 through 18, which I will share here briefly. And the actual question that was asked is, do you have information that my client was operating his vehicle in a careless or reckless manner? Do you? And the answer was just, I don't know. I know nothing about your client. It wasn't an exoneration of the defendant Maruva's driving as it's characterized in both the briefing and in the oral argument that was just presented. So I just wanted to clarify that reference before we proceed. With regards to the the defendant's hybrid motion for summary judgment here. There's not a lot that's in dispute factually because Maruva admits everything. He testifies as to the location of the wreck, as we heard, testified that he was stopped at a red light before moving forward. For purposes of this motion, we don't contest that. The plaintiff does not, for purposes of the motion, contest that Maruva had a green light at the time that he wanted to enter the intersection. But what we do contest is the applicable case law, and that is absolutely crystal clear that a driver approaching a green light still has an affirmative duty to maintain a proper lookout and look for vehicles approaching the intersection. And Maruva admits that he knows that. Maruva admits that he sees all the time vehicles running red lights, trying to beat the light. So he testifies unequivocally that this is a foreseeable type of incident that happened. He testifies that he looked to his left. However, he makes very clear that he did not see the blue pickup truck that was approaching that ultimately collided with Maruva's vehicle and then was diverted from its path over onto the other side of the median where it hits the plaintiff's vehicle. It's very clearly a proximate cause in fact, and a foreseeable cause of the incident was Maruva proceeding into the intersection when it was not safe to do so. He does not offer any type of excuse for why he does not see the approaching blue truck. He does not offer any type of he doesn't say that his view was obstructed. He just says he doesn't see it. With regards to if he sees other traffic over to his left, he provides some conflicting testimony in his deposition as to that point. When we get into the the key issue, though, to understand on all points is foreseeability. And Maruva's testimony is the most important piece of evidence in relation to all the motions for summary judgment that the court is considering here today. And Maruva's testimony establishes that Maruva knew that he had a duty to exercise ordinary care and maintain a proper lookout before he entered the intersection, whether he had a green light or not. It establishes that he would see it all the time that vehicles would run red lights and try and beat a yellow light. So this was a known danger. He testifies that he looks, but he doesn't see anything. He offers no explanation for why he sees no approaching vehicle. He testifies that he enters the intersection, that he's hit, that the force is hard enough to total his vehicle, and that he never saw that truck until after he got hit. So I'd like to dive deeper into foreseeability, as that is relevant to all of the issues, all of the motions before the court today. So with regards to the plaintiff's no evidence motion for summary judgment, I'll stick to that, though the topic is relevant to everything. We see the plaintiffs move for no evidence motion for summary judgment on various affirmative defenses and inferential rebuttals, including the sudden emergency defense. Now, the elements of a sudden emergency defense are that the situation arose suddenly and unexpectedly. I apologize. I'm also having a connectivity issue here. That the emergency was not proximately caused by the driver's own negligence, and after the emergency arose, the driver acted reasonably and prudently. However, the issue that is never addressed by the defense is suddenly and unexpectedly. This was something that was very expected by Maruva. That's synonymous with foreseeability. And my apologies, Judge. Did you?
No.
Oh, that's synonymous with foreseeability here. And Maruva testifies unequivocally that he sees this kind of thing happen all the time. Now, in response to plaintiff's no evidence motion for summary judgment with regard to sudden emergency, defendant only cites to a few brief sections of the defendant's deposition testimony. So the proposition first, pages 33, line 18 through 34:19. That section doesn't even address the incident, and that's the most on point part most on point portion of the deposition that the defendant actually cited in his briefing. But the testimony is it's total tautology. So it's cited to support the proposition that defendant testified candidly that he could not have taken evasive action against a hazard he never saw and had no reason to anticipate.
Counsel, your connectivity is really bad. I've read all of this. I'm going to take it under advisement, and I'll let you guys know in the next week or two, okay?
Your Honor.
Thank you, Judge.
If I may briefly, as to the affirmative defense portion of it, at least as it relates to the pre-existing and subsequent condition, because that I feel hasn't been touched on. I wasn't able to touch on that. Plaintiff's own testimony is she has a laundry list of pre-existing conditions dating back many years. I mean, it was, I believe, almost a 4.5-hour deposition given these pre-existing conditions. There's also a laundry list of subsequent conditions that were addressed or that have allegedly been addressed through treatment that we are contending is not applicable. And that is all covered in her deposition testimony, sworn deposition testimony.
Okay, guys, thank you. I'll take this under advisement and we'll get you a decision in the next 2 weeks. All right, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
And for everyone else, we'll be back in a second.
Where you at? All right, here. I can
Okay, guys, you there?
Yes, Your Honor. Good afternoon, Your Honor.
All right, did you guys work anything out?
We did, Your Honor. The parties have reached a settlement in this case. We just need a little bit of time to paper it.
That's great. That's great.
Yes, sir.
All right. How much time do you need?
Well, we're set for trial on the 21st, but I think we'll have it done. I just don't know if we'll have it closed by then. So I just ask if possible, if we could remove the trial setting and have 30 days to get final documents in.
That is fine. The one issue I have is there's a couple ways we can handle this just because I know it's settled, and this is on, remind me, this is on which case?
The plaintiff is Cavanis and Sadie Perry, 25-03511.
We had so many here. Okay, yeah, there we go. So we have a couple options here, Ms. Sims. One, you can withdraw your summary judgment. I could deny it without prejudice, or I could deny it with prejudice.
I'd rather withdraw it than have a ruling in case. I don't anticipate this is going to fall apart in any way, but just in case, I'd rather be able to reset it.
And I'm happy to move the trial setting too, given everything. So, Rhonda, put this on a 30-day DWAP. Ms. Sims, I'm going to trust you that you'll follow notice withdrawal today on the summary judgment. You know the new rule, how that all works. So, make sure you follow that today. And I'm glad you guys worked everything out.
Thank you, Your Honor. And then on the other motions that you're not going to hear, since they're not restricted, such as the rules for summary judgment, then
you don't have to pass the hearings on.
Okay, perfect. Thank you, Your Honor.
All right, why don't we do this? Ms. Coleman, Tony, let's go on the record on DC 3511 Cavanis versus Indio Property Management. Council, make your appearances.
Go ahead. Sorry, Regina. Regina Palmer Coleman. I have the pleasure of representing the plaintiffs in this matter. Kimberly Sims on behalf of the defendants.
All right. As I understand it, the parties have reached this case. Is that correct?
Yes, Your Honor. The parties have reached a settlement of the entirety of the case on behalf of all parties.
Is that correct, Ms. Coleman?
Yes, Your Honor.
And as to the summary judgment, the move-in defendant has decided to withdraw that. Is that correct?
Yes, Your Honor. The defendants withdraw the motion.
All right. The court is going to take this off of the trial docket. I mean, you're still going to file the notice of withdrawal, but take it off the trial docket for July 21st. We're going to put it on a DWAP docket for 30 days from now. And you're going to file a settlement letter with me today, correct?
Yes, Your Honor.
All right, guys. Thank you so much. You have a great rest of your day, okay?
Thank you, Your Honor. May we be excused?
You may. I'm glad it all worked out.
Thank you.
Hey, so Mr. Easter and Miss Regard, did you guys work everything out?
I think we have, let's see, we have about 4 of the requests that we'd like to talk about, but otherwise we've worked out a lot of it.
Okay. So there's a Caitlin Hill here. What are you here for, ma'am?
Your Honor, my hearing's not until 3:30. I'm here for a hearing on a motion to transfer venue.
Okay. All right. We'll get to you in a bit. All right. What are the 4 issues, Tony? Let's go back on the record on this case. What are the 4 issues?
So the first is plaintiff's request for production number 5, and really defendant is opposed in general to producing any communications between the plaintiff and defendant prior to the judgment that was rendered in the prior case. We asked that they produce these because we thought it was relevant to show intent to transfer and when defendant was on notice that plaintiff was a creditor. But it is, and I'll let Mr. Robertson speak for himself. It's his understanding that because plaintiff's pleadings say that the transfers were made to avoid the judgment, that only communications produced on the date of the judgment and afterwards have to be produced. It's our contention that
Any
transfer.
any communications about the transfer need to be produced.
Okay, we specifically asked for any communications about the underlying agreement that makes plaintiff a creditor and defendants entities a debtor. We asked for those communications.
Why would that be? Why would that be relevant or discoverable?
It would show when he was on notice that his entities were debtors and that the transfers would be fraudulently removing any assets from plaintiff's reach. We want to see, when did he know?
Can I address this briefly, Your Honor?
Briefly.
Yes, sir. So just 2 paragraphs from their amended petition. In paragraph 12, they define the judgment to mean the December 16th, 2024 default judgment that was entered by this court in the prior case. And then in paragraph 28, which is part of where they set out their pleading for fraudulent transfer, they specifically say that our client made transfers to avoid said assets being used to pay off the judgment, capitalized as defined in paragraph 12. Our position is simply that if they had alleged, that he was making fraudulent transfers to avoid obligations to them, that's one thing. The plaintiff is the master of his own complaint, and here they specifically allege that he made transfers to avoid paying off the judgment. The judgment did not exist until December 16th.
Given that language, I'm going to go ahead and just restrict it to communications about the transfer that were made after the judgment. All right, what else do we have?
Your Honor, just very briefly, that objection, that basis for relevance was not brought to our attention until we were brought to that breakout room, so it wasn't actually really ever raised. But we can move on to the next one. I just wanted that brought to the court's attention.
And what else we have?
Next, we have request for production 12. And that's when we asked for all documents related to payments that either the defendant or some other individual, any payments they made under the underlying agreement. The reason that plaintiff is asking for these documents is because one of defendant's affirmative defenses is failure to offset and is failure to mitigate damages. So we just want to see their document showing what they think the correct damages are here and what payments they think weren't made. I think Mr. Robertson said in the breakout room that he thinks that affirmative defense is no longer applicable. And if they amend their answer to remove that affirmative defense, then I think we're okay. But that just hasn't happened. So we just ask that any payment history, any payment documents be produced pursuant to a compel order because of those affirmative defenses.
Mr. Robertson, are you withdrawing that defense?
I will confirm with Mr. Hale on that this afternoon, but I believe that's true. I don't think it's an affirmative defense to fraudulent transfer. It went to a previous fraud claim that's now been dismissed by the court.
You got to decide now, Mr. Robertson.
So it's mitigation. Yes, I really don't see how there could be an affirmative defense of failure to mitigate when it comes to a fraudulent transfer claim. So yeah, I don't either. I don't think it has any relevance, Your Honor. It's withdrawn.
It's withdrawn. Okay, great. What's the next one?
Great. Request for production 13 also had to do with that, so I will move on from that one. The last is interrogatory number 6. And in interrogatory number 6, we asked for identification of all the bank accounts that the defendant and his entities used, including the names of signatories for each bank account. Defendant has indicated that they will provide that. We just need the signatory information to know who was in control of these bank accounts according to the bank statements. And defendant has said that they will provide that. We just want it to be included in the motion to compel order.
All right, Mr. Rob, I don't know why that wouldn't be produced, Mr. Robertson.
I told her I'd get her the signatories to the bank accounts. I've got no problem with that, Judge.
Okay. All right, guys, give me an order on this. The order should say that this was heard over Zoom on July 6th All parties were present. It was on the record.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, guys. Have a great, and get me that order by Wednesday, okay?
Yes, Your Honor. And Grace,
Thank you, guys.
I take that to mean that the order that you submitted this morning that was broader.
I will revise that, yeah.
Revising that. Okay, thank you.
Thank you, guys.
Thank you, Judge.
Okay, are all parties here for the motion to transfer venue?
Your Honor, Michael Pizzulli, I'm here on behalf of J. Anthony Custom Homes.
Jeff Benton, plaintiff.
Caitlin Hill for defendants Munir and Salim Charania.
Your Honor, Noah Andel on behalf of Corey Chambers and Compass Re Texas LLC.
Okay, I didn't see a response to this motion, so is this agreed to, or?
It's opposed, Your Honor. I didn't file a response.
Okay, let's proceed.
Your Honor, this case has, I believe, 5 total defendants. It's based on a personal injury claim that happened in Collin County in Fairview, Texas. So the personal injury claim was in Collin County, and then all 5 defendants either live or the natural people all reside in Collin County. And the venue in Dallas was based on the fact that Compass Real Estate Company has, I guess, their primary place of business in Texas listed as Dallas, but the real estate contract in this case was signed and took place in Frisco, Texas, in Collin County again, and the real estate agent is based in Collin County, and so it's in the interest of justice and the convenience of the parties for this venue to be in Collin where the incident occurred.
Response?
Your Honor, one of the entities that we filed suit against is Compass RE Texas LLC. They're the listing agent for a home that was being toured by my client when he was injured. And the real estate agent that works for Compass is Corey Chambers. So Compass RE Texas LLC is headquartered in Dallas County. That's the principal place of business in the state of Texas. I think in the response, they note that it's a New York organization, or their principal place of business in the U.S. is in New York, but I don't believe venue to be improper. And I don't think, I read through the motion, I don't see anything in there saying that they're not headquartered in Dallas County. So they're a defendant in the case. They're in Dallas County, and that was the venue that was where we filed. And I think there's also a forum nonconvenience argument. And I just feel like, we're talking about one county away. So if it's not improper, I don't see grounds for a transfer, and I don't believe it's improper venue. So then it would go to the forum nonconvenience argument. And, we're here on a Zoom call. All the attorneys are in Dallas County, and we're talking about an event that happened one county over. So I don't think it's inconvenient when one defendant is in Dallas to have the case held in Dallas.
Transfer denied. You have a proposed order?
I'm sorry?
You have a proposed order?
I can submit one. I didn't hear. Did you make a ruling, Your Honor?
Right.
I'm so sorry. The transfer is denied.
Thank you, Your Honor. I can submit a proposed order this afternoon.
Okay, and you guys are set for trial on February 16th, 2027. Just give me an order, okay?
Yes, sir. Yes, Your Honor. Thank you.